Mr. Zachary, whoever was listening to that call would have know that there's money on the head of whoever did that. It interweaves into the retaliatory nature of what's going on at that place and time between the two groups. So the state feels that this topic, because Zachary's right there when the phone call's made, it's not as much about what the individual who made the call, if they, what they meant, if they actually had $10,000 on someone's head, but the fact that that's made gives credence to the retaliatory nature, and also their knowledge that obviously putting money on someone's head is a thinly veiled threat of violence to action that. So that's why the state feels Zachary.
Mr. Short.
It seems to me that well, first, good morning, Judge.
Good morning.
This all seems to tie in with what we previously discussed. My issue isn't so much about the call and the contents of the call and Woody having money put on his head. My issue comes in when my client is somehow, this is attributed to my client.
All
so right. I don't believe it can be attributed to my client. In and of itself, I don't have a problem with it. It's okay when they try to link it. So I guess that's my answer.
Okay. And, I think that just as I put parameters on the last item that we took up yesterday evening, I think the same parameters are on this one, unless you can establish that Mr. Stillwell is there when they return and hears this, then this would go only to Mr. Copeland's knowledge.
Yes, Your Honor.
Okay.
When you say, did you mean, Your Honor, Mr. Zachary's knowledge? Or I didn't quite understand.
Mr. Zachary and Mr. Copeland. I mean, they're both present for it, but the point being not Mr. Stillwell.
Okay.
So yes.
Your Honor, number 23 is also on the same topic.
Okay.
And so Mr. Shard had objected to hearsay about who shot up Mr. Bennett's mother's home. This portion, the question that Detective Dennis from listening to the crime hack said, what kind of gun do you think Shannon had on him? And then Zachary says, I don't know. They had an AK and another 223. It was two 223s and an AK. There's not much more other than kind of the portions we have discussed. It's not like Mr. Zachary goes into much additional detail about that night at the home of Big Boo when Mr. Copeland would leave and come back and here's the phone call. My reading of this, listening to Detective Dennis and Zachary's conversation, is Zachary is stating, by my listening and reading, that he's like, they had an AK and 223s. He's saying, because he's not in the car, he doesn't know, because he makes a comment shortly thereafter where he's like, I don't know how many guns they had in the car. But to me,
when they got in the car, yeah.
Yes, Your Honor.
So yes, to me as well, that sounds like at the point in time when they all leave out, which seems to include Mr. Stillwell, here's what they had on them in the way of guns.
And Your Honor, here's my concern, and it's, I get that this session, this interview, the police are just trying to get Mr. Zachary to dump knowledge on them, just get as much information as possible. I get that. Obviously, the detective's job is a little different than an attorney's job. I don't know, as I sit here right now, what Mr. Zachary is basing any of this on. Does he know, for instance, is he saying he saw my client go into a car holding a 223? Or is he saying, well, I just know Shannon to carry a 223? See, and those are the type of things, if I was prepping a witness, I would clarify. I think we need to clarify exactly what he means, because if he just knows my client to carry a 223, if that's what he's saying, then that is something very different than seeing my client get
Yeah.
into a car with Woody with a 223.
Agreed. So on page 113, lines 11 and 12, there's some unintelligible. Do we know that?
To me, I don't know if other
Okay.
people may find it intelligible.
Okay.
I don't have anything written there.
Well, maybe if we just listen to this part of it.
Yeah. Yes, Your Honor. Out the shooting of the Little Wayne tour bus, and they also asked some questions about the murder of Donovan Thomas.
Uh-huh.
And so this kind of falls in the category of the state. If we discuss this topic or ask Mr. Zachary questions while he's on the stand, we would lay out and either meet foundation or not meet foundation for, from just this interview, how he's saying this about Birdman's beliefs on or feelings towards these events.
Mhm.
And so this is one that I still think it's fruitful to do what we're doing and going ahead of time, but some of it is contingent on Mr. Zachary's
Okay.
on the stand questions.
Your Honor, for instance, just to let you know what the unintelligible is, on 122 line 12, Mr. Zachary says, nah, Birdman, they asked, did he order that murder? Talking about Birdman, Mr. Brian Williams. Nah, Birdman, like he mad at, when he thought Thug had something to do with the tour bus, he mad at him. Like, I don't know how Mr. Zachary can convey Mr. Williams, not Jeffrey Williams, Brian Williams' thoughts
Knowledge
about, well, not even knowledge, is speculation, what his feelings are about an event that neither of them were present for. That just strikes me as a whole lot of speculation on Zachary is speculating about what Brian Williams is speculating about. And I just can't see a world where that would be coming in.
Okay, well, I think that Mr. Atkins is essentially conceding that unless the state is able to establish a foundation for how Zachary can testify to what Birdman is feeling, that they wouldn't be able to use this. Right?
Correct, Your Honor.
Okay.
Your Honor,
Yes, sir.
the state of Georgia had Mr. Brian Williams on their short list. They did not call him. Same with Rich Homie Kwan or Mr. Lamar. I specifically asked the very first witness in the case. He testified several times. I can't remember his name. Belknap, Belknap. He's with City of Atlanta Police Department. Whether he is alleging that Mr. Brian Williams was part of any type of conspiracy, any type of gang. And he said, no, it's entertainment for show. He has no information. He was not making that claim. So it's total hearsay. There's no co-conspirator link. This would be just, I heard him say something or I didn't hear him say something. So I would object on that basis.
Okay.
Besides, reading someone's mind and what your court said.
Okay. Well,
I'd like to cross-examine Mr. Brian Williams.
What he's saying is, no, I don't think he had anything to do with it anyway, but.
Your Honor, if I thought Detective Belknap had discussed some of that Mr. Birdman was a blood, but we're not saying this is a co-conspirator statement
Right.
for one, and who the state calls or doesn't call. is irrelevant to the evidentiary considerations for today. Is
Sure.
the state's position.
I mean, I agree.
I disagree because being a blood, quote unquote, I'm not saying that the gentleman is, I'm not trying to tarnish him or maybe say something accurately, but that's come out in this trial. That's not illegal.
Agreed.
Okay.
Agreed. I just think as to this issue, if and when it potentially arises at trial, we take it up then. But at this point, the state understands that they don't have a foundation to be able to use this.
Correct, Your Honor.
Okay. All right. 123.
Your Honor, we addressed part of this yesterday in terms of Detective Gaither asked, do you think that Thug ordered that against Nutt, talking
Right.
about the murder? And Zachary says, no, they're just trying to get a name. This had came up yesterday. It kind of falls in a similar category where the state would have to lay more foundation for how Zachary knows that their motive, knows someone motive. Is it because they told him? Is it because he interacts with them daily? So we would not just ask Mr. Zachary cold, why did they do X, Y, Z? There would have to be adequate questions for that foundation.
All right.
Well, we would object to an order now to eliminate the first word of no. I don't believe that Jeffrey Williams ordered that. If you're saying it's a co-conspirator and he would know about it, then that is relevant. And so I don't want to ask from the questioning.
I'm not sure if I follow you.
Okay, so I think that the answer by Mr. Zachary, the direct question is, do you have any evidence that Mr. Williams, Jeffrey Williams, knew about or ordered the
Right.
killing? The answer is no.
Right.
Then he goes on, and that part, I agree, should come out. But the no, or the nah, N-A-H, I assume, should not be struck if you're striking things.
Okay, well, I'm not striking or not striking this right now. All of it could only come in if there's some sort of an inconsistency and they're presenting it as, to impeach or something like that. So with,
In Your Honor.
I mean, I guess there are two separate, do you think that Thug ordered the murder? And the answer to that, and then
The next part.
the people that he thinks did do it and why.
Understood. And I just don't, the first part to be part of the equation of that potentially is not going to be put.
Okay, so yeah, I mean, they would be two separate items.
Yes, Your Honor. And the way I could potentially see some of this coming out is if Mr. Zachary was asked questions about, because in this interview, he describes, and I mean, he tells Detective Dennis YSL is a gang, and he talks about who he interacts with. And so if we asked him questions about, how does that work? People making a name for themselves or going up in rank, some of these could become relevant if he says, I don't know what you're talking about, things like that.
The same ruling that I made with regard to there are a couple of other comments. Yes, you would be able to use that part of it. They're just trying to make a name to show, okay, yeah, this is how it works. And you have told us this before.
Correct, Your Honor.
Yeah. So that's kind of separate as well. And you could use it for that. And then there's, if you are using it to show, what he knew or didn't know about who ordered it, then you need a foundation for his knowledge of that.
Yes, Your Honor.
Okay. That clear for everybody?
Yes, Your Honor.
All right.
Your Honor, could I just add one, a 24B to my list? And
Yeah,
it doesn't
sure.
even show up.
Okay.
It doesn't show up in the transcript, but I think it affects Mr. Williams, frankly. Off the transcript where, well, you see it, but the transcript's not accurate. On 123, line 12, the woman who's investigator Gaither is asking about the rank of who's the leader, and she's suggesting that Mr. Jeffrey Williams may be the leader of YSL, and Quindarius says, who said Thug's the higher up, essentially. I think that's pretty accurate quote.
Okay.
And Investigator Gaither, and it shows up at the end where after it says unintelligible, she's actually interrupted by Quindarius.
Okay.
And she says, that's just what I heard. I do believe that it would be improper to play Investigator Gaither basically an out-of-court statement suggesting that she's heard from other people that Mr. Jeffrey Williams is the higher up of YSL. It's confrontation clause and hearsay.
So, Your Honor, Detective Gaither she's testified previously in this trial, but this portion, when she says, who said Thug is hired, Detective Dennis is like, who's the boss, who runs YSL? Zachary says, he was not right there when they started YSL. And they're like, who started it? And he says, my brother and Slug, who is Trontavious Stevens, also known as Tick. And so the state's not going to ask Zachary, did Detective Gaither tell you that she believes Thug was hired? That is not what a question that the state would ask. But however, this portion could become relevant in terms of he's acknowledging YSL's a gang. When she says, when she says, isn't Thug the highest, or however she phrases it, he's like who said Thug was higher, which acknowledges there's a gang with some kind of hierarchy, or because he would have been like, what do you mean higher over what? So
Okay.
So the state, if Mr. Shart's objection is to Detective Gaither's, words saying, I heard Thug was higher, the state does not intend to be asking Zachary about Detective Gaither's opinion on Defendant Williams or the YSL gang. But this portions of it in relation to Zachary saying who he believes started YSL and his own brother, that kind of stuff, he has adequate foundation. We'd have to ask him on the stand to explain that. That's kind of the state's.
And I don't have a problem with anything that Mr. Atkins just said. All I'm saying is, and they could ask about that, and quite honestly, I think the defense likes Mr. Zachary's answers. All we're objecting to is if it's played, there's a prior inconsistent played to the part that Investigator Gaither says, that's just what I heard, referencing that Mr. Williams is the leader.
Okay, so you're saying if for whatever reason it does end up getting played, strike that's just what I heard part.
Correct.
Any problem with that?
No, I agree with Mr. Shart on that.
All
Or
right,
the state does.
sounds good.
Your Honor, the next one, to make it easier on everyone. So I think there was a bond hearing or something that Detective Dennis or Gaither, they're referencing a court hearing and arguments that Mr. Zachary's attorney made. They were like, those are good arguments. We all know that. Anyways, the state is not going to be asking. We're conceding this in regards to, it's a really brief back and forth where they're laughing about a court hearing, about the argument on bond, about the gang. And so the state's not going to be asking Mr. Zachary anything related to number 26.
Okay. So redacted by agreement.
Your Honor, and also on number 27,
Yes.
there is and he says that earlier. And so when Detective Thorpe, who's the lead detective on the Donovan Thomas murder, comes into the room, there's some greetings, and then Detective Gaither kind of tells Mr. Zachary, Thorpe's been working really hard on the case. We've been talking to a lot of people. We appreciate your honesty. The state's not going to I don't think this will come up. So the state's conceding this portion in terms of, I'm not going to be asking Mr. Zachary about if Detective Dennis and Gaither thought he was truthful or doing a good job.
Okay. Thank you. Was that all that one needed to cover?
Correct. It's just them bolstering,
All right.
basically,
Yeah.
on the tape.
Okay. All right. 135.
So, Your Honor, this one, Mr. Zachary says, I think Nard was driving them, and then Thorpe just kind of repeats, okay, Nard was driving. This is when they're speaking about, because Zachary at the beginning of this interview talks to Detective Gaither and Dennis some about Donovan Thomas's murder, and then they get Detective Thorpe to come over because he's the lead homicide detective. And so he goes into more detail at that part. So the state, this part of the interview, Mr. Zachary, as like all of these interviews, he's not saying directly where this is coming from, but the state's position, kind of similar to yesterday, is that the primary source of Mr. Zachary's knowledge is from when he says defendant Stillwell, defendant Kendricks told him that night. He also has a brief mention when he goes down to Miami with them that he had some kind of conversation with with Demise McMullen, Nard. And so he does say, I think Nard was driving them. The state's position, and again, this may depend on the foundation of the questions he's asked, but the pool of information that the state's aware of from Zachary's statements is other co-conspirators telling him about either their own involvement in the murder.
Okay.
And Your Honor, my stance, as previously stated, is that if Mr. Zachary is claiming the source is anyone other than my client, Mr. Stillwell, I would object. However, if the source, I understand the court's prior rulings, and if the source falls under the court's prior rulings, I understand what your ruling is.
Okay.
But I don't, as I sit here now, I have no idea what his source is with some of these statements that he's making.
Okay. Well, I think we have to take the entirety of the statement into consideration, but that would fall under my prior rulings with regard to the co-conspirator exception. So that'll be permitted.
Your Honor, I believe next is number 29, which is 136, line 18 to 137, line 11.
Okay.
In this portion, Detective Thorpe says, after the shooting, do you know what happened to the cars and the guns? And Zachary says, yeah, they dropped it off at OG Bentley's spot, who's Mr. Treadwell. And he asked them, do you know if the guns are still around? Did they get rid of them? And Zachary says, most likely got rid of them. He's supposed to have gotten rid of them. And then they have a conversation about, Detective Gaither's like, how do they usually get rid of guns? And Zachary's like, well, this is the first time. Usually we keep the guns. And
Okay.
Detective Thorpe asked if anyone got a word to shoot nut, which is one we kind of just addressed. And he says they just wanted a name. So it's speculation, hearsay. I think the speculation objection is coming from where he says, do you know if the gun's around? He's like, they most likely got rid of them. The state's position here is that, again, his source of them going to Kevin Treadwell's house is, again, the same co-conspirator statements. And he is not definitively at the house or see them bury the guns in the backyard or throw them in a river. But I think it's reasonable to think that from his conversations with them that they went there to get the car and the guns so that they couldn't be caught. So the speculation is Zachary's not physically present at Mr. I have no information that he physically saw these guns being hidden. But I think because he spoke with co-conspirators about it, it is not as speculative as that question
Right.
seems.
He has a basis for knowing from his other co-conspirators that they were dropped off.
Yes, Your Honor.
What happened to them after that? That is what he's speculating. He knows the purpose was to get rid of them, but whether they were actually gotten rid of past OG Bentley's place, he doesn't know.
Correct, Your Honor.
But that they were dropped off, he does know.
Correct. And because he kind of answers, like, it's clear that he doesn't exactly know if this particular portion through impeachment came in, it's, he's kind of telling, like, I don't know exactly, I think they did, but it makes sense in the context of the conversation he has a couple hours after the murder.
Right.
That
All
they
right. Well,
wouldn't, so.
with those parameters.
And it just goes, I've stated my objection. I understand the court's ruling. However, I do believe that 9 and 11, lines 9 and 11 on 137 are a little different because, again, that is just, from my understanding, just pure speculation about motive.
And this is kind of similar, Your Honor, in terms of the state would have to ask him foundation about how does he know they wanted a name?
Sure. All right.
Hey, on this one, Your Honor,
Hang on just a second. I need to actually figure out where we are, because so that actually, even though 130.
I wrote it.
So that went past what is notated on your number.
It was supposed to say 136.18 to 137,
Okay.
line 11.
All right. That's, I looked down and I'm like, well, we're talking about 137. Okay. All right. Now I'm back with y'all. Okay. 138.
So number 30, number 30 on my list. This transcript is really rough here, so I'm just gonna, if the court allows me, just
Sure.
on 138 line 6, Mr. Zachary is talking about Shannon. So Shannon's the topic.
Okay.
Gaither says, right. Zachary says, like, Thug really wasn't messing with him. He was around Thug as Woody's friend.
Okay.
Okay. So they're still talking about Shannon. Line 13, right. So once he did that, it was kind of like, we can trust him. Zachary says, yeah. And then line 17, she says, we know he a shooter.
Okay.
That's my objection. The law enforcement saying, we know Shannon's a shooter.
Okay.
And so, Your Honor, this portion, which I agree with what Mr. Shard's saying, that this time hack states. And so they're talking about, it starts with Zachary has a comment where he's like, usually Woody and Moontunk are doing all the shooting. And then Gaither's like, well, did Mr. Copeland slow down with his BS? And he says, when he's around a lot of folks, he gets pumped up. And they're kind of asking, how did Shannon Stillwell get into the picture? And so he's like, well, he was friends with Copeland, comes around, and Zachary says, no one really knew Mr. Stillwell that well. And then, the way that what they're talking about is after the murder of Donovan Thomas.
Mm-hmm.
Gaither's like, well, once he did this murder of Donovan Thomas, that we could trust him, know he's a shooter. And Zachary's response is, he started messing with Shannon hard. I take the he being defendant Williams. And so the state feels that Detective Gaither's question to get Zachary's response, if the right questions are asked on the stand, could be relevant because, for one, Zachary on some level confirms what she's saying, because he's like, after she says, now they can trust him, they know he's a shooter, Zachary says he started messing with Shannon hard, kind of confirming that, yeah, he started messing with him or hanging out with him or being closer with him because he was a shooter in the context of what Zachary's saying happened on January 10th, 2015. So the state feels that it's not just Gaither in a vacuum saying, we know Shannon's a shooter. I'm not going to ask Zachary what's Detective Gaither's opinion, but yes, my apologies, Madam Court Reporter. But it could become relevant because of asking Zachary in the context of his relationship with Mr. Copeland, how defendant Stillwell came into the picture, that this exact clip, if the right questions are asked, could become relevant to get Mr. Zachary's response.
Okay.
But if this clip is played, line 13 says, right. So once he did that, it was kind of like, we can trust him. And Zachary says, yeah. And then we could easily go to line 19. He started messing with Shannon and then they go into Woody becoming a new Slug and Shannon becoming a new Woody. But none of that requires line 17, law enforcement saying, we know he's a shooter. That's my objection, specifically that line. I understand. Right.
So up above on line 6, what gets said then? They already knew Shannon liked something.
I just have it say that until. Like that until. It doesn't make a lot of sense, but that's what they're kind of interrupting each other.
Yeah.
My note, Your Honor, is Zachary says, nah, so lines like 2 or 3, Detective Gaither says, did Woody slow down with his BS? And Zachary says, nah. When he's seen that there's a lot of folks around Woody, they pumped him back up. No one knew Shannon like that until Thug, not really messing with him. He was around Thug because he's Woody's friend.
I agree.
Yeah, that's on the prior page, right?
That's 138, line 10. Right, Mr. Atkins? That's where you're at?
I believe so. The transcript lines I'm looking at, I went back through and added, from listening to it. So my line and page is a little off, but
Well, I see did Woody slow down with all his BS once Nut got killed? Or was he still?
Right. That was on 137.
Right.
And then
This is the no, he'd get the answers, no, he'd get pumped back up, or what?
yes, Your Honor, it's Zachary says, nah, when he's seeing that there's a lot of folks around Woody, then he pumps back up. And then he says, no one knew Shannon like that until Thug, not really messing with him. He was around Thug because he was Woody's friend.
And then Gaither says, right. So once he did that, it was kind of like, we can trust him. Quindarius Zachary says, yeah. And then Gaither says, we know he's a shooter, or we know he a shooter.
Right.
And I don't know why the Gaither would be allowed to make a declaratory statement, whether she's talking generally that law enforcement has
generally his
determined that he's a
role.
shooter,
Right.
or if he's a shooter in this case,
Right.
that's a question for the jury.
Right. But I mean, assuming that he started messing with him hard after that is actually in response to the statement, we know he's a shooter.
Well,
And maybe I just need to listen to this part.
I view it more of a response to line 13, where she says, so once
Once
he did that, it was kind of like, we can trust him. And he's like, yeah. And then you could easily go, he started messing with Shannon he started messing with Shannon. He repeats himself. I don't know why. And then they don't really, there's no real meat to what Zachary says, because then they move on to Woody. But my concern is specifically with, we know he a shooter.
I understand. I'm going to listen to it. It may not elucidate anything, but where is this timestamp?
So, Your Honor, I have a little bit before this is at 3:25:44.
Okay, I'll just start there. And you did send this video or no? I can't remember.
I will double check, Your Honor.
Okay, just make sure y'all do so that I can
That's
listen
right,
to
we
it.
did give a thumb drive, so it should be.
Oh, so it was on the same thumb drive that the other one was? Okay, I know there were like 4 items on there.
Yes, Your Honor.
Okay, all right, well, I'll listen. Y'all can remind me to circle back on it. Do we have that other thing queued up?
Yes, Your Honor, and I wanted to make certain that I got the exact time because I just pulled it over to this time frame when you want to listen to this.
Yeah, we're going over.
And I mean, maybe we can just listen to them both while it's up. I don't know.
Keith, forward it to Carrington.
Your Honor, for the record purposes, we're pulling up, we're gonna start at 3:08:50.
All right, and this is, we're going back to item number which?
We are going back to this actually kind of tackles a couple items because this is all about who shot Lucci's mother's home. But I believe what prompted us to go back was,
Item number 23, was that the one we were?
yes, Your Honor, I think it was 23
Yeah.
because we weren't sure if Zachary physically saw these guns or.
Right, okay. Right. I've been told that if I plug a headphone into the computer, if I'm on Zoom, maybe I can hear it better. I don't know if that's true. I have to get on Zoom first. Are you playing it through Zoom or are you playing it off your computer? All right, let me then join Zoom. And figure out where this might plug in.
Your Honor, before we play, so 30850 is when they first start, literally Detective Dennis asked him who shot up Lucci's mother's home. And then I'm happy to start there for the court if the court would like. There's about 3 minutes of conversation, but when he specifically starts talking about what kind of gun did Shannon have on it, which is more tethered to number 23, I can jump just to that part. I want to just ask the court if you wanted me to play a little bit before or go right to when he's discussing the part about who had what firearms.
If you think the context will help, that's fine.
Okay. We'll start at 30850, Your Honor.
All right.
Officially 30841.
So let's get to this. Who shot up Lucci Mama?
Shut up, Lucci Mama. I'm telling y'all, I just got work with me.
We just, bro, like you're doing great.
Roy, Shannon, and Lil Pokey.
From Boulevard?
Nah, those the nephew. The Pokey's in jail right now. Quentin Pittman. So, how did, cause that was the gun that you had, that you got caught with. No, that's some gun. So, how did Woody end up with that gun that day? We was at Boot Mama House, Big Boot Mama House. Mm-hmm. And we was like, hey, Pokey, is that right? Okay. Then when they came back, they ain't even tell them what they did. What kind of car were they? They were in what? It was in that white Chargers, Woody Chargers. Okay. And then the boy, Mushu, who he did Lucci, Mushu, yeah. He called Boo. Like, when Woody got back, he called Boo. Like, Boo, he got in. Boo, like, what? Like, somebody just shot up Lucci's mama house, and mom got shot. And Boo, like, don't tell me how they did that. Cause they come back and say that. Mm-hmm. Don't tell me how they did that. Then that when Woody got scared again, cause Mushu, like, got 10,000 and Woody did that.
Who had the Monto gun?
Woody. So they actually came back and said they did it, or y'all just assumed it? No, they said they did it. He finally said it when Woody, like I told you, Woody got scared when they said he got 10,000. Mm-hmm. Like, man, we just shot up Lucci Mama house. So because Lucci was close with Nut, they just... Lucci was hanging with Kel. Right. That's what he's all about. Right. Kel. Like, Nut didn't go get killed. I don't know what made him do it. Did you know Nut? Yeah. He gave me $20 and stuff. You know, I put him on, get some gas money, phone bills, doing stuff like that.
So he's like a big homie.
Yeah, he cool with the whole city. That's what everybody said.
So everybody speaks highly of him, but he still was a street nigga. So
yeah, he was trying to, but he, like, every time I see him, so I feel like I don't gas in the car, so I give him $20 for
So they look at you like the little like,
yeah. I ain't no harm.
Basically. So, what gun did Shannon, you think Shannon had on that?
I don't know, they had AK, and another 223. It was 223s and an AK. I know they had that big AK. That was poking on them.
The AK was?
Yeah. So
And what's Shanahan?
He had one of them, 223.
Oh, yeah, they gave it to
I don't know how they got in call. I just know guns go back out.
So answer this question. So when we were in court and you found out that gun,
All right. I mean, it sounds like, to me, like he's saying, essentially, this is what they had with them when they left out.
That's the state's, we're in agreement, Your Honor.
So I'm going to permit that.
Overrule the objection and permit it?
Yes.
Yes, sure.
Okay, so can we move to the other one that I was going to listen to? So we know he a shooter.
Yes, Your
Is that
Honor.
pretty easy?
Yes, Your Honor, it is.
Okay.
So we're going to 32544 for the record.
All right.
Three 2529.
You know her name? No. You know where she rented it from? So, after the shooting, do you know what happened to the car and the guns? Yeah, they dropped off at OG Damage Farm. Do you know the guns still around or they got rid of them? More likely they got rid of them. I think when they dropped them off at Fence Spot, he pulled it got rid of them. How do they normally get rid of guns? I don't know. That ain't the first time they ever usually keep them. Yeah. Okay. So, did anybody give word to shooting up, or this is just an opportunity? They just wanted the name. They just wanted the name. Cause it used to be one and more to them on our soon. They just wanted the name. So did Woody slow down with all his bullshit, or once Luck got killed, did Woody slow down with his stuff, or was he still? Nah, when he seen that he had a lot of folk that ran with him, then he hung back for Moody. Yeah. But see, everybody really knows Shannon like that until then he did. Right. Like those when we messed with him, he was around for we Woody from him. Right. So once he did that, it was kind of like we can trust and we know he can shoot. He started mixing with Shannon for he felt started mixing with Shannon.
so they put Woody to the side and Shannon back to the Woody spot.
Yeah. So like Woody took Slug's spot. So Shannon and
It is really, I don't know that it can be determined that he started messing hard with him is in response to him being a shooter, to him doing that, to him coming around with Woody and it being okay because he's Woody's friend. I mean, I just think that I don't think you can base that Thug started messing hard with Shannon on him having been a shooter. I'm going to exclude that.
Understood, Your Honor.
Okay. So moving to 144. Give me just a second. All right.
Your Honor, with this next one, I'm in agreement. This is probably this section where Zachary is stating that his older brother used to hang out with defendant Stillwell. And then Zachary says something along the lines of, until Shannon got locked up,
Okay.
the state would omit or ensure that the jury never hears about Shannon getting locked up, but may ask him about him knowing his brother.
Okay. That takes care of that objection.
Yes, Your Honor.
All right. Thank you.
Now, this next one, Your Honor, 32, I'm pretty certain she's not referring to Shannon. I think she's referring to Terry Rivers,
Okay.
who I don't know if his name has come up in this. He's certainly not in this case. He's certainly not indicted. My understanding is he's alleged to be associated with some of these gentlemen in some way, but then Gaither adds, yeah, I know Terry Rivers used to steal ATM machines, and I just think that that's just
Okay.
throwing another.
Your Honor, the state agrees and concedes this.
All right.
this
If
portion
y'all
of
are
it.
going to agree, tell me before we
Yes, Your
listen
Honor.
to the argument. We can save Mr. Sharp and my voices.
Yes, Your Honor.
All right.
There is some agreement with this next number 33.
Okay.
So they're talking about the Dexter Montgomery shooting, which was in Act 36. We've already introduced at trial. Mr. Zachary was not present. He admits in this interview he doesn't have any personal knowledge
Right.
about it. The part of this that the state may get into is the photographs used in that case. For example, there's gas station surveillance stills.
Okay.
He recognizes, for example, Demise McMullen, who was one of the defendants in that case.
Okay.
The same photographs that Detective Gaither and Dennis are showing him during this portion are already in evidence. And so depending on, there may be some questions with those exhibits,
Okay.
but we're not going to be asking Mr. Zachary anything about what happened to Dexter Montgomery because he doesn't know.
All right. You'll just be using it.
That's fair. I mean, I don't, Mr. Murphy, DK, took the stand and he's acknowledged that it was him and Nard. So I don't think that's really in dispute. I would add though, and this doesn't show up in the transcript, Investigator Dennis has a habit of doing this with a lot of these gentlemen he interviews. He takes out a picture of Dexter Montgomery's head, which is actually in evidence. And he just goes into this big thing about, oh, he's got half a head. What do you think of that? And I just don't think that's appropriate.
Okay.
But if for some reason there's an issue about who was there, I do concede that Quindarius Zachary, after Investigator Dennis does the half a head thing, does show him pictures from the scene, and he says, oh, that looks like Nard, that looks like DK,
Okay.
so I concede that he does do that.
So to the extent that this is him identifying, yeah, that's that person. I know that person. That's this person. You don't need commentary about, oh my God, look at this guy's head. You know.
Agreed,
that.
Your Honor.
Okay. Great.
Number 34 also is in agreement.
Okay.
This is in relation to something that's been suppressed,
Yeah.
rate of a house.
Told me
So
that already.
that's right, Your Honor.
Okay.
35, this is a portion where Mr. Zachary they're asking his girlfriend, Summer Good, says that basically she doesn't like him hanging out with them. And then he mentions defendant Stillwell because like Zachary gets in trouble with them. And so the state feels that, in the context of when, and the Detective Dennis is going to be also, he's testified before, but he's going to testify again. He's on the witness list and he's in this interview. This could become partially relevant in regards to this. In what's going on in Mr. Zachary's life at this time, he's trying to pull back, in his words, and kind of get a fresh start, spend more time with his girlfriend, things like that. And so this is kind of wrapped into why at this moment in time he's in jail. He's speaking with the police. And so the fact that his girlfriend, who he's kind of self-admits is very close with, interacting a lot, she doesn't like him hanging out with them. And so the state does feel like this could become relevant with the right questions of Mr. Zachary.
Okay. And it could. So I think at the point in time when y'all think it does, that's maybe something we'll just have to wait on.
Okay.
Okay.
Your Honor, the next one, number 36. So Zachary is discussing when his brother died. And what he says is he died when Haiti Gang robbed him.
Okay.
Haiti Gang is kind of a subset and affiliated with If Gang. And so the state feels like this is very relevant because Zachary's older brother, who in an earlier part of the interview, he says was one of the, Zachary says,
Founders.
correct,
Yeah.
that the fact that Haiti Gang robbed and killed his brother, that is relevant to how he kind of got involved in a gang. So it's not as much about what happened. We're not gonna be asking him details of his brother's murder, but this portion could become relevant when we ask him questions about his brother if he, so that's why the state wants this to come in, at least in relation to, because the objection was discussion about the murder of the witness's brother. So it'd be a brief discussion of that, if at all, depending on how he answered.
Okay. Well, I mean, 159 looks to be like the details of it. So even based on what you're talking about, this part may not come in.
Yes, Your Honor, like we won't be asking him like what street his brother that happened on, or
Okay.
we would just be asking him, or we may never get to a part where we have to play this to discuss this part, but it's just about the fact that Haiti Gang robbed and killed his brother.
Okay.
That's the part the state wants, is relevant.
All right. All right, number 37 is on, starts at the bottom of 163.
Your Honor, this portion is when he's discussing the shooting of Dwayne Carter's tour bus. So Zachary, Detective Dennis personally sees Zachary when he arrives. They're at a nightclub outside. And then there's a lot of things that happen, some of which Zachary's present for, some of which he's not. And so he is not in any vehicles. He never, it says he's in a car that did the shooting, things of that nature, but he mentions being with different members that are there, like co-conspirators, defendants, other witnesses. You know, they go different spots in the city before they arrive at the nightclub. They go to places afterwards. The events of this shooting become something that gets discussed amongst each other. And so the objection was, the investigator testified about his theory, hearsay and speculation. The state's more concerned with what Zachary, you know, what he states happened. Like, for example, he's discussing what cars people went in, like Detective Dennis asked, did they put Thug's sisters out? Like, because some people got in different cars. And Zachary says, he's saying, I don't know where she lives, but he mentions, he confirms like Max is who he calls his sister was there. And so, and Mr. Shard, correct me if I'm wrong, if there's a specific portion, but Zachary's knowledge of what happened that night will be something we'll be asking him about. And so this may be one that we have to, it really depends on the questions he asks, because it would only be impeaching him if he kind of backs off the details of that night. And so I will not be asking him about Dennis's theory of what happened, but depending on what he testifies to, certain of these portions you may need the question asked in his response, but this is kind of very much wrapped into how he testifies because he goes through a lot of different facts of that night.
All right, and it seems like, Mr. Shart, you're objecting to man one, who's one of the investigators, saying, here's what I know, or here's what I saw.
I am
right?
objecting to that. I mean, my understanding is that's Investigator Dennis, and he's already testified to what he saw on the stand.
Okay.
And
so they wouldn't be offering that for it to get in anything about what he actually saw. This would be if it becomes relevant to, if the answer becomes relevant.
this is the dilemma, Your Honor, as I see it. I concede that it seems pretty clear that Quindarius Zachary was at the compound that night. The compound, I don't know if Your Honor is familiar. I've been to the scene. It's
Gigantic.
It's very large.
Yeah.
It's unclear to me. I know that he was not on 285. That's pretty clear. Or he's saying he wasn't on 285 or when buses were shot.
Mm-hmm.
What's unclear to me is where he was when he's claiming people were leaving out and switching cars.
Right.
He's definitely giving that information. It's unclear to me if it's based on, and this was a widely reported event. There was hip hop gossip, internet sites almost immediately that are reporting what happened, different theories. So it's unclear to me whether he's there when he's saying people were leaving in certain cars.
Yeah.
And I concede if he was there, if it's established that he was there and he's saying he saw things with his eyes, I mean, it is what it is for me, and I'll have to deal with that in cross-examination. But what I don't want is the state for him to say, well, I wasn't there for that part, and then the state to start impeaching him. Well, didn't you say this and this and this? And then it was just all based on speculation or internet gossip or other things. So I don't know what his source of information is for some of this stuff. And that's what I'm struggling with. I understand in a certain circumstance, he would be able to testify about what he saw. Well, in any circumstance, he'd be able to testify to what he saw. But I'm not sure he saw these things. I'm not saying he didn't. I don't know.
Well, I think we already made rulings, and by we, I guess I mean me,
Well,
about that.
you made rulings, my recollection is you made rulings about what Demekion Garlington allegedly told him about the Donovan Thomas situation. I don't.
Okay, I thought we had talked about him. Maybe we haven't, but I mean, to the extent he gets on the stand and says, yeah, I wasn't there, I don't know any of this, the state can cross-examine him about what he said before, and it may be that it's established through, not cross-examine, but examine, and then y'all can cross-examine him about whatever the inconsistencies are. Even if he says, you know what, I don't know who got into any car. I wasn't there. I was in Alaska at the time. They can cross him. I mean, they can examine him, impeach him with this.
Because that would be clearly inconsistent with his prior statements. But my concern is if he says, you know, as the crowd was dispersing, Investigator Dennis saw me and said my name and I ran.
Yeah.
And I ran from the scene and got into a car and left and went home. And then they're like, well, didn't you say that Shannon got into this car? And it turns out that his testimony is actually that he wasn't there for that part. And what his prior statements were based on something else.
But who knows whether it's true that
I understand.
what his testimony is, you know, whatever, next Wednesday, that he says, oh my gosh, the cops saw me and I ran and I went home and got in my bed. We don't know whether that's true or not. So he's still going to be able to impeach him. And then y'all are going to have to ask, you know, hey, you know, how are we supposed to believe that this is true? And he can say, we can see it on my ring camera. I walked in the house, and y'all will just have to explore that. I can't, I mean, we don't have any way to know. They're telling the truth. They're supposed to swear to tell the truth and then tell the truth, but we don't know that. So I can't do what it is that you're asking me to do here. Okay.
I understand the court's ruling.
All right.
Your Honor, number 39 and number 40, they all are in relation to the same topic regarding the shooting of Dwayne Carter's tour bus.
Okay, hang on. Did that cover 38 and 37?
It definitely covered 37.
Okay, because I thought we were on 37. So
My apologies, Your Honor. So
Okay.
for 38, really 38 through 40, and we can take them one at a
Okay.
time. They all talk about this same event.
I would agree with 38 that what your ruling was just covered.
okay. All right. So moving to 39 and 40, is this also still the same incident?
I'm catching up.
Me too.
Okay, so on 39, excuse me, 30, we're on 39. He is saying that someone said we shot up the tour bus, but there's a pronoun we, and it's unclear who the declarant is or where that's coming from. He's saying that people showed up at the studio later that night and someone said we shot up the tour bus.
Okay. Okay. So does he ever say who showed up at the studio later?
He does mention where various people come, but I don't have memory of him ever clarifying exactly. Well, I will say this. Give me 1 minute. I'm trying to find this part in my more detailed notes.
Mm-hmm. I mean, it says after they shot up the bus, what happened? We met up at the studio. What were they saying? They're basically saying we shot up the bus. But we don't know who the we is from here, but we may know who the we is from if he somewhere else says, here are the people that showed up at the studio.
And Your Honor, there is a portion where he's discussing who switched cars.
Okay.
And Zachary, so Detective Dennis says, so Max, referring to one of Defendant Williams' sisters, and Shannon switched spots. And Zachary says, told everyone they were going to watch him, call him, meet at the studio, say we're going to go shoot up the tour bus. And Detective Dennis is like, they said this? And Zachary says, I don't know what the hell made him shoot up the tour bus anyways. Oh, my apologies. Yes. They were at the studio. Say, we're going to go shoot up the tour bus. Detective Dennis says, they said this. And Zachary says, yeah, I don't know what the hell made him shoot up the tour bus anyways. Detective Dennis, who said it? And Zachary says, Pee-wee, referring to Jimmy Winfrey, who was the individual. It was a Cobb County case, but relation to this incident. And then Shannon said it, and Detective Gaither's like, well, who was more hype about it? And he says Shannon. Now, I believe this context is before the shooting, whereas what we're talking about is afterwards, but this is kind of very much wrapped into how, when we get to this part of the interview, we'll be asking him questions about that night. And so depending on how that questioning goes and what his answers are, he will have to have, the foundation for who he was speaking with or interacted with. And I actually say a little bit further, Your Honor, and I can actually play this if we need to. I have 3:45:49. Detective Dennis says, after they shot up the bus, what happened? Zachary says, we met up at the studio. Detective Dennis says, they came back to Metropolitan. What did they say? And Zachary says, they say they just shot up Wayne's tour bus. It was Max's truck with them in there and Pee Wee's car, referring to Mr. Winfrey.
Mm-hmm.
Don't know who Pee Wee was with. And Gaither's like, so both cars up there, other cars following them? And he says, probably follow them to Expressway, not sure if they followed them to the shooting.
Mm-hmm.
And then he just goes into a diatribe about how Mr. Winfrey came into their friend circle. So I don't see where he definitively says who it was at the studio told him. But this event happening, there's a lot of communication about it because it becomes a big incident that happened. And so I don't know definitively who at the studio told Mr. Zachary, but
I mean, I know that this is alleged to be a gang act, and I would assume part of your RICO.
correct, Your Honor.
Okay. The only complication is with our potential limiting instruction about, it would only be charged against the people that it's charged against.
And it's Act 39. It's only in relation to the RICO count because this incident happened in Cobb County. So this is.
That makes it easier.
Yes.
Okay.
Yes, Your Honor. So.
All right. So then that it is, yes.
Your ruling, only Mr. Winfrey is alleging that overt act. He's not on trial.
Okay, but it is alleged to be an overt act in furtherance of the RICO conspiracy, right?
It is an act in relation to count one, which every defendant's charged with count one.
Right. Okay.
It's true. But also the overt acts have a statute of limitations of 5 years from the time that the indictment's returned. This is in 2015. There's a series of overt acts that Judge Glanville said, I understand your argument. We'll get to that. He just passed on it, basically, that those could not be considered by the jury in reaching a verdict. I asked for a special verdict form. So all of this, I just want to raise your attention.
No, I appreciate that if that's yet another pending determination for me to make, but I would think that they can still be, nobody's being, even if it were in Fulton County, nobody's even potentially being convicted of this act, but I would think that statute of limitations or no, it can be considered by the jury in determining whether the people charged are guilty of a RICO violation. So if you've got case law that says differently, and if you already filed it, just let me know where to find it. But if
And
is that the argument that you're making, that they cannot even consider when they're considering whether anybody is guilty of a RICO violation, acts that there is a statute of limitations for and that statute has run?
So I think when you say they, my position.
They, the jury.
Okay, so the jury can only, they're going to have to find the overt act because it's a conspiracy.
Uh-huh.
That overt act must be, in my opinion, and the case law that I'll again show the court or show this honorable court would be within 5 years.
Okay,
But-
well, if there's case law that says that, then certainly I'll take a look at it. And it sounds like that issue is still on the table to be determined, right?
Yes.
Your Honor, being a newer addition to this team, I wasn't present when I'm being told that this issue has been addressed before. And so if there's going to be further, I don't have the case law right now, but in terms of Act 39, the fact you can charge overt acts in furtherance of a conspiracy to happen outside of Fulton County. That part is clear.
Oh, yeah, no, he's not talking about where it happened. He's talking about statute of limitations having run.
And there is to my knowledge, and we can, I don't have a case to cite right now, but we can, if this needs to be briefed, we will brief it. But that is not the state's understanding with,
Not the court's understanding of it either, but I mean, been wrong before. I could be wrong right now. It is not my opinion that matters. It's what the case law says that matters. And if it has already been briefed by both sides, super, just point me to which brief and which response I should be looking at. And it very well may have been addressed before, but not decided. Ms. Lev, do you think it's already been decided?
Judge, that's what I was just saying. I
Okay.
believe that this issue was raised by Mr. Steele very early on, and I believe that it was decided in the state's favor against his position.
Okay.
But I was saying that we can check the transcript for that, because my firm belief, because I remember the argument, is that it was actually argued and decided. We will also look for an order to that effect. But I specifically remember Mr. Steele's assertion regarding a statute of limitations. I believe that it may have been Mr. Floyd that argued that.
All right.
But we'll check and see.
All right. Well, thank you. And whatever you find, send to me or point me to it at least. Now, this is not really an evidentiary ruling that's been, assuming it has been decided. This isn't really an evidentiary ruling. This is a ruling that's going to impact how I tell the jury to deliberate on issues and what kind of verdict form we need. And so it really is something that I don't find myself bound by whatever the prior ruling was, even if it was made. I want to take a look at it myself and make my own determination based on the case law. So y'all just, again, point me to what I ought to be looking at, and I'll look at that and then make a ruling.
And Your Honor, so that I'm making certain that we are speaking apples to apples, Mr. Steele's assertion is that because the statute of limitations on the overt acts have run, that the jury is not allowed to consider the overt acts?
That's what I think he's saying. No.
I'm just saying to deliberate for the actual verdict. Let's say that we're asking for a special verdict form. There's 191 overt acts in count one. Let's say the Honorable Court grants a special verdict form, and every one of any overt act within the statute of limitations, within 5 years of the return of the indictment, says not proven. But then there's one or more overt acts before 5 years of the return of the indictment that says proven. Our position would be the overt act is not satisfied because the statute of limitations bars the conviction because the overt act was previous. I'm not talking about evidence because that shows the history of the quote organization.
It could just be intrinsic or whatever. So
Right.
I mean, okay. So I mean, but I do understand they can consider it for whatever, the history and how it all fits together. But you are saying that case law bars the jury from returning a RICO conviction if the only overt acts that they find to exist are overt acts the statute for which has run.
Exactly.
All right, well.
And the state opposed at our previous argument a special verdict form that was the Honorable John Floyd. And what Judge Glanville said was, we'll address that later.
Okay, well, we
happened.
need to address that.
We'll do it anew, obviously, because you're.
What? I think you just lost the battery in your.
I did. I'll put it in writing because, I think it's a fascinating issue, but we'll put it in writing.
Okay, and if it already has been put in writing, you don't have to do it again. You can just point me to, this was, motion number 50,000 filed on May 1st or whatever. If you haven't put it in writing yet, great, do that. And same for the state with regard to a response. And if there is a ruling, I want to look at that too. I mean, I don't want to reinvent the wheel either, but I will make my own determination about it.
Yes.
Okay. All right, so where were we?
Your Honor, we were on 176, line 6 is
Yeah,
what we were
and
just
like-
discussing.
Okay.
And just to be clear, if the foundation is laid that Mr. Zachary is falsely asserting that my client stated that, then I understand that that's just going to be a subject for cross-examination. However, if it comes from a source, allegedly comes from a source other than my client, our stance would be that that would be either rank hearsay, something he read off the internet or something, or if it was said to him by someone else.
Okay.
I'm just using an example.
Sure.
Pee-wee, that would be spilling the beans. And that's,
Okay. Well, and I'm rejecting your spilling the beans argument with regard to all of these things as they're going down and immediately after they go down. Now, if his source is off the internet, then that's a different story. But you have you have a basis for, I mean, they all get, whomever they get together at the studio afterwards and talk about it. So.
Yes, Your Honor. And Zachary says we met up at the studio, and then Detective Dennis says they came back to Metropolitan, and he says they say they just shot up the bus. So he's kind of responding to like a person he's around.
Mhm.
So, but understand, and we will ask him the right foundation for that before just asking an out of the blue question of, they told you they shot up Little Wayne's tour bus.
Okay.
And certainly the next two, Your Honor, the state is in agreement in regarding Mr. Shard's number 41, page 178, line 1 through 2. It's a comment that Gaither makes. So the state,
I'm going to withdraw. Can we deal with 140 first? 40 first?
my apologies, I skipped over that.
40 is just him saying what he feels that there were cars following on the expressway. He wasn't there for that. And he actually says they probably followed them to the expressway, but I don't know if they followed to no shooting.
Yeah.
So he's just speculating there.
He's basically saying beats me. Yeah.
Yes, Sharon, we will
Okay.
not be asking about
All right.
those cars on the highway.
40 is out by agreement.
41, I'm going to withdraw, and
Okay.
and I just think it's needed to add context.
All right.
I think it would be improper in some ways, but quite honestly, it involves Mr. Steele's client and Mr. Adams' client, and Mr. Zachary says no. So I think it's needed to provide context to the no that Mr. Zachary gives.
All right. Thanks.
And Your Honor, number 42, the state's in agreement of.
Okay. All right. And then 43 is our last item on this statement.
Your Honor, we're also conceding number 43.
All right.
We'll not be talking about this
Okay.
topic
Thank you.
with Mr. Zachary.
All right. Then we've gotten through this statement. All right, we'll take a break in just a second. Housekeeping wise, did Ms. Love, were you able to email over to everyone last night what you have so far?
I sent some, and then I have the broader folder containing Mr. Sledge's exhibits that numbered, and so I will share that. I haven't shared it because I was actually still typing in it just now, but I will share that with counsel for the defense. And Your Honor, as I look towards next week, it would be Mr. Sledge before Mr. Zachary.
Okay.
So,
So we did this in the wrong order, but. All right, that means we need to get to all of what might be used with Mr. Sledge today.
that's the folder that
Okay.
they're about to,
All right, well,
and it's not,
not voluminous.
I don't consider it voluminous,
Okay.
but, it's not.
Okay.
I'm gonna drop that.
All right, so go ahead and send that now. And then we've got to sort out potential jury instructions for when they come back today. We're not going to have court on Friday. Okay. So let's take a 10-minute restroom break and come back and get to work. No. Somewhere else and see. All right, if y'all have just now gotten the evidence that is gonna go with witness Sledge, I don't know if y'all are ready to tackle that right now or.
It can't be, because it's still sending and uploading. So I'm on Dropbox trying to.
All right, well, what all is it? Because, I mean, presumably they've gotten it all before in Discovery anyway, right?
They definitely have, and I can do that for the
Yes.
I can address, Mr. Sledge gave a prior statement that's can be played on evidence reviewer. Following his arrest for the 2015 alleged shooting of houses, he was arrested as well as Mr. Zachary.
Okay.
I can address that. And there was one on what Mr. Adkins said, there was one jail call that was identified, and I can address that as well. I don't know if there's more, but his statement I can address, the jail call I can address.
So those two, he's correct, identified those and given them to those. The statement is the statement we mentioned earlier. And the jail call is that Mr. Shard is correct in those. And if we are ready to respond to whatever it is that they bring up while we're sending the rest of it.
Okay. The prior statement he made in 2015, he's brought in regarding the ag assaults, and he is questioned. He's Mirandized. He gives a statement. He denies any involvement. He later pleads guilty.
Okay.
Or offered, I'm not sure. He pleads somehow. He resolves it short of trial. He's just denying being there. So I don't know under what circumstances that statement would be used to impeach any testimony. I suppose he acknowledges that he knows Mr. Zachary. So I guess if he said he doesn't know Mr. Zachary, I guess that could be used to impeach him, but it doesn't seem to be a statement that would be used to impeach him or would necessarily be played. His jail call, I've listened to it. It's essentially him. He had a preliminary, he was charged with the murder of Donovan Thomas by Detective Thorpe. The state has since determined that he is not responsible. He had a prelim where no probable cause was found. After the prelim, he calls his significant other. I'm assuming it's his significant other. It sounds like it from the context. And he basically talks about the testimony at the prelim. He speculates about who witness 1, 2, and they used codes in the prelim, witness 1, witness 2, witness 3. He speculates about who that could be. And he basically says, it sounds like witnesses 1, 2, or 3, and, or some combination of within those 3 people really threw Shannon under the bus.
Okay.
So he's speculating, he's commenting about testimony he heard from a detective about what witnesses told the detective, and is just giving his commentary. It sounds like people really threw Shannon under the bus. I have no idea why anything from that phone call to his significant other would be admissible in this trial.
And Judge, the phone call would only be necessary if Mr. Sledge said something contrary to what he's indicating in the phone call. And I think a broader context, a broader sort of description of that phone call and what he says is necessary. So a few things are going on. Mr. Shard is correct. He's There is a prelim. He's talking about stuff that has happened. What is most important in terms of the preliminary hearings are that Mr. Sledge is, he's privy to information that is given in other preliminary hearings of other YSL members. And he's aware that during his own, they are talking in terms of witness 1, witness 2, witness 3, rather than giving names.
Right.
What he says is, Lil D told, and Lil D is the witness that we've just finished listening to, Mr. Zachary. And he said, I can tell Lil D told because of, and he gives the information that was given by witness 1 or Lil D. He said, I can tell witness 1 is Lil D because he says this. So the fact that as he's discussing with his significant other, the information that he has learned while he's been in jail with other YSL members and in court, and he is not asserting that so-and-so lied or on Shannon. He is saying he threw Shannon on the bus, or they told on this particular person. That in conjunction with his factual acknowledgments in his plea agreement that he made when he entered a guilty plea in this case, we believe it establishes, 1, the nature of you do not tell. 2, he has knowledge that people did tell, and he is not saying this didn't happen. He's not saying this person just flat out lied. There's no way. And it also explains indirectly why certain things may have happened. By certain things, this part is just an argument that would be made later. But if I were to make a statement in closing arguments that, of course, Mr. Zachary changed his story, everybody learned that he told, and he knew that everybody learned that he told, and now he's being looked at as a rat. So the call that Mr. Sledge makes and the content of that call are necessary for a number of reasons, and they become very relevant when put in the context of other evidence that we will be introducing at trial.
Okay.
So we can play the call for the court. We have it. It's a single 15-minute call.
Fulton County Jail. This call is subject to recording and monitoring, and your location information may be collected and used by corrections and law enforcement. Tablet.com. During special moments as .net to learn more.
What should be telling Quanah for her to be doing how she be doing that?
Man, I ain't even talked to Quanah. I seen Quanah in the courtroom with Tip today. I swear to God, I ain't even talked to Quanah. I seen in the courtroom today with Tip. I was shocked when I looked back. Only thing what made me look back, cause when they first started calling the charge out, that nigga Peanut them dad punched the damn thing and got up and walked out. The folks did miss you today, though.
You know, Derek called me and told me everything.
What did he say about the bond, though?
He said,
Yeah, I'm sorry, but that is entirely too muffled for me to understand what they're saying. I'm happy to listen to it at lunch if I need to, but until I can figure out how to hear it through Zoom, or, you know, if y'all want to, sometimes attorneys will bring another speaker, but if I need to hear what's being said, I can't from there. Sorry.
So I do have things, but I'd rather test it and then, well, I can try and test it, but I can send it to the court.
I mean, if there's an interview we need to get through anyway, why don't we just do whatever the small, I guess, more discrete objections are to that interview.
So Mr. Sharp's characterization of the interview is correct. What he does during the interview is essentially he's telling the police, you know, you don't have to do your job. So there is there is no particular reason at this point that I see that we will be playing it.
Okay.
It is not, it's a statement that a witness has previously given, and if a reason arises, I just don't see a reason beyond, you know, you didn't want to tell him until I don't see a reason that I'll be playing it, but it's his statement that he gave, and he's denying it. He's saying to them, do your work.
All right. Well, Mr. Sharp, do you know what the discrete portion of that is? And then maybe we can just see whether, even if she does maybe want to use it for some reason, she can say, oh, I'm definitely not going to use that.
I didn't identify any.
Okay.
Speaking for Mr. Still, Mr. Still was not mentioned in it.
Okay. All right. Okay. So anybody else have issues with Mr. Sledge's 2015 statement that the state's probably not going to use anyway?
Mr. Williams,
All right.
if it comes up, though, obviously we'll.
Well,
There's nothing in that statement that is harmful to Mr. Williams,
Okay.
but, you know, depending on the circumstances, we'll find out.
all right. Well, anybody else? Silence from everybody else. Okay. All right. So, as to the telephone call, is there anything in particular y'all want to direct my attention to? Y'all know what it says, even though I haven't been able to distinguish it yet. Or you just want me to listen for the whole?
I just object. I mean, it's Mr. Sledge reporting to his significant other what happened in his hearing that day. And I don't know this for a fact. I believe that he had the prelim. I believe it was him and Mr. Stillwell together.
Okay.
I don't know that for a fact. I could be wrong about that. But he's just commenting. The investigator Dennis, I believe, is the person. It may have been Thorpe. And I wasn't at the prelim. I didn't represent Mr. Stillwell back in 2015. And he's just commenting on witness 1, witness 2, and witness 3, and who he thinks they are, and his significant others commenting back. I don't know why the state would think, because Mr. Sledge, who they're saying wasn't even at the shooting of Donovan Thomas. Okay, they haven't charged him with that.
Right.
I don't know why they think that the fact that Mr. Sledge isn't saying that's a lie about something he wasn't even at is somehow a tacit admission against Mr. Stillwell. It makes no sense to me. And
Okay, no, I mean, that I can see the logic of it. It may be that on that issue, it is inadmissible and not relevant, but in terms of him being able to tell from what witness 1 says and doesn't say versus witness 2 or witness 3, that he knows who that is, it may be relevant to their whole concept of everything that goes on within this YSL gang. Everybody shares the information for, and, you know, I'm tight with him and I know what's going on. So, which is one of the issues that they thought it might potentially be relevant for. Now, they'd have to have a reason to play it. And I think we're going to have to wait and see on that. But if that becomes actually why they're playing it, then I think I would overrule a relevancy objection to that if it's, you know, legitimate.
I don't foresee any situation where Mr. Sledge, I'm fairly confident is going to say that he knows all these individuals. He knows Mr. Zachary very well.
Yeah.
He was charged in a separate crime and pled guilty to that crime with Mr. Zachary. But even then, I would, even if it became relevant for that, which I can't foresee any circumstance, I would strenuously object to him commenting on other people's testimony about a case that
I understand.
against my client that he wasn't even present.
I mean, I
according to the
understand.
state.
And it may be that, and I think even the state's saying, I don't know that there are circumstances under which we'd be able to get this in, this would become relevant. If there are such circumstances, then I would think that much less than the entirety of the phone call needs to be played and we can limit it then. So maybe Miss Love, if you are thinking, or it starts to look like you're going to need it, then if you can, get with the defense beforehand and y'all come to an agreement, understanding what my ruling then would probably be on what part would be relevant to that and what part wouldn't, instead of just, hey, I'm getting this whole 15 minutes in now. Okay.
Yes, I can do that. That makes perfect sense.
All right. Okay. So then anything else on Mr. Sledge's, the evidence that might be used with him at all that we ought to be looking at beforehand?
So the other items that and I've shared, if I don't know if anyone has been able to, if it has shown up, but I've shared the link with everyone except Mr. Howell, whose name just wouldn't populate.
We just received.
Right. I just,
All right. So what other evidence is there? There's the phone call. There's this interview. What else?
so there are also the plea agreement, the video of the plea agreement of Mr. Sledge.
All right.
We have had the need to play other witnesses' plea agreements.
All right. Well,
at this point, if he's testifying truthfully, then we don't have any need to play that.
right.
If it begins to intimate that I didn't know what was going on, it wasn't really freely given or
Right.
anything like that, then we would want to show him entering that plea.
Okay.
We also have, and we may have already admitted this, we're checking the exhibits, but there is the video where Mr. Sledge is with Mr. Zachary, and they are threatening Kelvin Watts. We've labeled that, if we haven't already admitted it, as State's Exhibit 398 Yankee. There is Mr. Sledge's cell phone records, which we would be using or asking Mr. Sledge, is this your number? Was this your number at that time?
All right, and would that be the only purpose of the cell phone records?
Well,
Or you plan to be using the cell phone records to show some things?
to ask him about numbers within them.
Okay.
That he remembers.
Okay.
He doesn't, to ask him about specific
Sure.
persons and numbers.
All right.
And of course, we have Agent Bernie later on who
Is going to be able to say whose number is whose, I guess, right?
will be able to apply it. Now,
Okay.
we have Detective Dennis who would be able to say, and ADA Sprinkle, who would be able to say what we determined was the owner of the
Okay.
accounts for each the numbers that are relevant.
All right. Do y'all anticipate, did the defense anticipate objection to that? No.
You're saying, Your Honor, you're asking about if he remembers his phone number? No, I don't.
Okay. And how about the 398Y video being used with, I mean, if it's already in, then the evidentiary objection's been dealt with anyway, but we haven't, I don't know where that list is right now. And he's in the video?
He is.
Okay.
We're talking about the video with Mr. Zachary and Mr. Sledge. I don't think that's inaccurate.
Okay. If it's not, that will be 398Y.
Uh-huh.
And Mr. Sledge, I believe during his interview, he talks about that.
Okay. Is this like a music video?
No, it's a video, like a selfie video.
Okay.
Or someone filming.
All right.
Mr. Zachary, threatening Kelvin Watts.
Okay. All right.
If there's, we can play that, it's not even long, it's about less than 5 minutes long, probably about 2 minutes long, if there's a specific objection to that.
Y'all all seen it? Is there a specific objection that you know of now? Or that you know you might have?
Just want the instructions, I think, that you can talk about that we give you 105, which Williams is not in that video at all, and it's up to the jury to determine whether that should be.
All right, well, I mean, I keep asking for an instruction or a proposed instruction, and so far nobody has been forthcoming with one. So, and I've told y'all until you get me something to consider, there's not much that I'm going, the burden, the onus is on y'all at this point, okay?
I think we,
So, and considering this is our last day of court before we bring the jury back on Monday, now would be the time to do it.
Your Honor, you should be receiving that shortly.
Thank you.
And Your Honor, with respect to the video, well, I'll just wait to see what limiting instructions, because it goes to count 1
Uh-huh.
against each of the defendants.
Right.
So I'll just wait to see what the requested instruction.
Okay. So a potential limiting instruction, but with regard to anything else about the contents of the video, y'all don't anticipate an issue? Okay. All right. Any other evidence for him?
There's two social media posts made by Mr. Sledge on the night that Donovan Thomas was killed.
Okay.
And they are, one is Mr. Sledge is that night around the time of the murder, he's watching the Patriots and he captions it that he's watching the game, Let's Go Patriots. And there's another one, where he is shown watching the game
Okay.
with his, small child.
All right.
There is what we labeled Stacy Exhibit 399 Yankee. It's a video of Mr. Sledge. He is saying, if you go in the courtroom and tell, if you testify, it's not great. Basically, it's how do I say this? So you lie to your significant others, you lie to your family, and then you get in the courtroom and you tell the God's honest truth. Essentially, that's bad. I can play it. It's 13 seconds. I can play it for the court.
Well, does the defense know the video she's referencing? Yes, it's already in evidence.
Actually, Mr. Williams' video saying that is in evidence, not Mr. Sledge's.
Okay. Maybe not in evidence. 399Y Yankee.
And I'll just
All right.
share it so we can.
Okay. Share it via Zoom. All right. A sec to get Zoom opened. All right.
You can lie to your kids, you lie to your mama, but you get in the courtroom and in the investigation room and tell them punk ass people the God honest motherfucking truth. Pussy ass.
That's it. There's a word he uses at the end. But yes, that's the extent of that video. And this, we'd argue, it shows the sentiment that YSL members have towards, frankly, people telling them.
Okay.
Object to that.
All right.
That
And
may be that I think this video, it could be argued, shows Mr. Sledge's sentiments. Mr. Stillwell's not in that video. He's not speaking for Mr. Stillwell. I don't know. There was no vote to make Mr. Sledge the spokesperson for this group of gentlemen, and I would object. Mr. Sledge is not sitting here with us,
okay.
so I don't know how that's a comment.
He already pled guilty, right?
He did.
Did he plead guilty to the RICO count?
He did.
Okay. Y'all can cross him on that topic. What about the 2 social media posts with him watching the Pats game? Any contemplated objection to those? Okay, what else?
There's also a video that he posts, not a video, but a social media posting that he makes on June 24, 2015. Free little D, like right now. And that is, looking to share it.
Is he saying it, or is it just like a written post?
It's just a written post.
Okay.
It's just,
Okay. Anybody anticipate objection to that we need to deal with now?
I don't know specifically what she's oh, is that it?
on the screen is the post. Oh, and I need to zoom in.
I just don't know what the relevance is of some of these things. Like,
So 6/24/15, what's just happened? Why is he in? Why's the little D in?
This is
Which little D is it?
Tamika Garlington. And he has been arrested. I can tell you the reason that we're wanting the relevance of it.
Okay, what's that?
It's the urging of each member. We don't have just him. We have him saying free little D, free the other little D, free various members of YSL, as we have with other defendants that are currently on trial where, for instance, when Mr. Winfrey was arrested, Mr. Williams had free Roscoe shirts, they're wearing it. So they're advocating for the release of their fellow gang members, and it shows their solidarity, their support for, and the existence of the organization.
All right.
I would more accurately, in my mind, say that he's posting free his friend, and to the extent that Mr. Sledge says he doesn't know Lil D from Mechanicsville, that's that picture is of the Demikion Garlington, Your Honor.
Okay.
To the extent he says he doesn't know him or he's not friendly with him, or I mean that maybe that would become relevant, but
Yeah, I'm going to permit it over a relevance objection to show or potentially show the issues that Ms. Love has said she would offer it for. And of course, y'all can argue that all this shows is he's concerned about his friend, but that's a topic for argument. I think it is relevant, though.
Your Honor, there's one issue that I failed to bring up earlier.
Okay.
Regarding a video of a plea, and we dealt with this earlier in the trial, and I know that we did some redactions. I would object if they're bringing it in to show that if it becomes an issue and that a plea was freely and voluntarily entered, going through the Boykin rights and things of that nature, I would understand. Going through the state's factual rendition and their of the plea and just their testimony and their story, we would object.
The factual rendition, unless you have him then affirm, yep, that's what happened. And unless he's now saying, nope, that's not what happened.
That part is
it all just depends on.
That's exactly.
Okay.
Yes.
So yes, I mean, depending upon the reason that the plea might end up being potentially used. Yes, I agree with you. If it's to show voluntariness, then the factual rendition is not relevant, and I would not expect y'all to try to play that. If it is to say, dude, when you took your plea, you agreed that all of this is what happened, and he has in fact agreed, yep, that's what happened, then that's what I'm pleading guilty to, and it's not an Alfred plea, then the facts would be relevant.
Right. And so we've heard creative ways to sort of distance witnesses from prior acknowledgments that they've made. So some may have expressed a lack of an understanding, or some may have expressed feeling pressured. And then during their plea colloquy, they actually shut it down and okay. So yes, but understood. It's not necessarily all in. It is just going to depend upon the reason it's being offered. And just as with whatever the reasoning for the phone call, and I'm not going to say this as to every little piece of evidence. This just needs to be how y'all operate going forward. At the point in time when you anticipate, oh, I actually am going to use this. I didn't think so before, but now I am, or whatever. You tell them so that all of us don't have to be scrambling. Okay. Okay.
Advance notice to the other side about things that are likely to be evidentiary issues, so we can deal with them at an appropriate time and not be sending the jury out every 10 minutes.
And so, Judge, we will definitely abide by that instruction. And I guess we'll ask for more granularity. a little bit more clarification if in the middle of questioning.
Obviously. And I mean, that's why we're kind of going through all of this now, is so that most of it you're already going to know in the middle of questioning. Here's how I can use this. Here's the part that needs to be redacted out, whatever. But, you know, like for one of them, you said, I just really don't anticipate in any way using that. And then if you're like, oh, you know, we're in the middle and we take a break at lunch, you tell them at lunch, at the beginning of the lunch, yeah, I'm going to use this after all. It's just as much heads up, as much advance notice as possible. And given that you are supposed to be providing all of the evidence in detail for, you know, the first 30, and I think you're almost to the point where you're supposed to provide it for the next 30, this shouldn't be an issue. But, okay. Mr. Harvey. You wanted to say something.
Yes, one other point, Judge. With the previous exhibit and this exhibit, we previously had a ruling and discussions about the commentary on these.
Oh, I can't even see that because of what's on my screen. But yeah, I don't think, unless the comments are relevant, let's not have those on there.
So
Now, sometimes the comment might be relevant.
But we don't know who's making the comment. We can't cross-examine the commenter. And we have had Judge Glanville rule that the comments come out previously.
Okay.
I mean, who is this that's commenting? 70 likes, one comment.
Okay.
You know,
all right. So I agree with the prior ruling, and I don't know that this is how you were going to present it on the stand when you use it. This just may be how you've got it now. But make sure before it shows up on a screen with a jury that whatever limits have been placed on this, you abide by them. I mean, I saw the slide from the opening that had something on it that had been specifically talked about and ruled that you had better not in any way put that before the jury. And lo and behold, it's up there on the screen. Not going to get back into it, but that should not happen again. If you know that comments aren't supposed to be on here, you need to make sure before you throw any slide up. And I'm not saying that this was how you were going to use it. I know you're just giving this to us right now, but just make sure everything is clean to the way that it is supposed to be. Okay.
And to be very specific, so there's no misunderstanding, the comments, what the court has just said about unless there is a relevant portion in the comments, for instance, the witness on the stand comments about something else.
Okay.
And for those instances, I would do as the court has instructed and say, hey, these are social media posts. This one right here, I am going to attempt to keep in, and I'll share it as I'm going to present it. Right now, it doesn't have.
Nope, you're not going to share it as you're going to present it. You're going to share it with each tranche of 30 witnesses. Okay. If you know somebody has this incredibly, damaging, I want to use this comment, I'm going to use it with this witness. Tell them as you're going through your tranches of each 30 witnesses.
Okay. Yes.
Okay.
But the comment that is made by the witness, which is on the left side, that we would do on the screen.
Yeah. Mr. Harvey agrees that, yes, he's talking about the likes and comments and what have you on the other side. Those don't need to be included.
I was in agreement with him.
All right. Super. Thank you. Everybody's in agreement.
So the next one, Your Honor, is the post on June 15th, 2015, where Mr. Sledge is saying free Jimmy Winfrey and FUXK12 and KANT, hold the real one down. And he tags Mr. Williams on the left side.
Right.
So this is absent the comments on the right. This is the post that we would.
All right. And if you already have that as an exhibit number, you can tell us now. Otherwise.
It's State's Exhibit 401 Yankee.
Okay.
And the exhibit number, as we have it listed, is up in the upper left corner, almost imperceptibly.
Oh, all right.
Quite see.
Okay.
Does the court want me to just keep going?
All right.
So
I'm not hearing any objection.
The next one is Stacy Exhibit 402 Yankee.
All right, we don't, if you've got a series of free XYZ, free ABC, and they're all pretty much the same, then I don't need to see them all right now. They're all going to be the same issue, and you can do that.
Okay. This is not saying free anybody, but it's saying happy birthday.
Okay.
Mr. Stillwell.
Okay.
Stop putting me on fucking fake pages, because I don't give a fuck, man. What y'all say, what y'all do. Anybody want to see more to? I'm here. I don't hide. And I do not run for fuck niggas. You did.
Your Honor, this is relevant, and we would seek its submission for you hear the comment, but then at the bottom underneath the photograph, it has FR for real 100 100, and then the two little green snake emojis.
Yeah. Which are alleged to be a YSL gang symbol. Okay.
Yes.
Yeah.
We've already admitted the content, the group photo that is now labeled states 405 Yankee, but because of what Mr. Harvey pointed out, that we had taken out comments, I was not certain without looking back at it whether the YSL, FUXK, the rest love had been admitted. And for that reason, I sought to admit the whole post, since this is the witness that made the post.
All right. Well, you can go back and look and see. Let me ask y'all, with regard to these things that are electronic as we look at them, are y'all printing out a hard copy and using that?
No. So we are in fact giving to the court reporter and showing to the defense contemporaneously with publishing
showing it
to the
on the
jury
screen.
digitally. Yes.
Okay.
And
so I guess the reason I'm asking is, so whenever you used 405Y before, how do you now know whether it contained the comment at the bottom or not?
We have given the court reporter hard copies.
Okay.
That is not the case with all of the exhibits that have been tendered. We have, but that's how we know what.
So y'all can go back, well, you can go ask Ms. Weaver on 405Y, does it contain the comments or not?
Right, we can go back, and it won't be labeled 405Y. We have the list of the exhibits, and we have the description.
Okay, well, whatever it was labeled at, let me ask you this. If it was labeled 205Z before, and now and we find out that it does in fact contain those comments, you're not going to re-tender it as 405Y, right?
No.
That's only if it doesn't contain the comments.
Correct.
Okay.
And definitely to the extent my colleague is expressing that the court may not understand me to be saying explicitly that we are printing our exhibits that we have tendered and shown digitally. And we have given to the court reporter the physical printout of any digital exhibits.
Okay, the physical printout as well as the digital exhibit, right? Or by the end of trial, you will.
Right.
Right.
For the
Okay,
digital.
that's fine. And I know that Ms. Weaver, and whenever we get probably in a couple of weeks that the jury's gone, we'll take up, let's figure out what evidence is actually in and out. Maybe that's what we'll do that week. Not the whole week. We'll get lots more done than that. But I do know there is an issue with regard to a couple of defense exhibits because they were only shown, I think, on a laptop, and we'll just have to sort that out at some other time. But we need to think about going forward. If you're walking up to a witness and showing them something on your laptop, you might need to take a screenshot of what's on that laptop so that then the court reporter knows what it is. Okay. All right. What else?
This is a similar
All right.
social media post?
All right, so I'm going to basically rule generally, unless you think that there is something particularly, oh gosh, I think that there's going to be some other kind of relevancy or 403 objection to something. The posts that are just seeming to show his posting about gang life or indicating gang insignias or anything like that, those would be relevant. And if you think there's some kind of 403 thing as to something, then pull that up. But I don't need to go through every little bit of evidence. I want to be hitting the evidence that you think the defense is going to have an objection to, that we need to hash out beforehand.
I don't. So
Okay.
there are 3 videos that are also social media postings. I don't see anything that would be 403 there. For instance, 416, Stacey Exhibit 416 Yankee has Mr. Sledge. It also has Mr. Williams and other alleged associates or members of YSL in it. And they are sort of just congregating it.
Okay.
I can since I've shared it, I can let defense look at it. It's labeled in the shared document as well.
All right. Well, and ideally, again, after they've got the big list with the 30 and all of the exhibits, then they can do their homework and they can actually tell me, like Mr. Short did for Mr. Zachary's statements, hey, here's what I find objectionable about that. So once y'all got that, y'all can do that with everything and it'll be more smooth. All right. So, but you think that pretty much for Mr. Sledge, after what we've discussed, you'd be good to go, and the defense likewise. Okay.
I do. I have shared with the defense just the case that is like the printouts from Mr. Sledge's federal case. I don't foresee, I'm not going to try and tender that as evidence. There may be a portion of it that I reference or need to reference, if depending on how he testifies, to refresh his memory or something, but I'm not going to try and enter his federal case as evidence. And I think that's it.
Okay.
Mr. Sledge. And his certified copies of the conviction, his proffer, his factual acknowledgement, the physical documents, those we have labeled as states 394.
Okay. All right. I've gotten the proposed limiting instruction now. And Mr. Matthews, you are requested in my other courtroom for the trial calendar. You know what that issue is. So can you run up there to the judge handling that case real fast? We'll recess I'm probably just going to stay here, but we'll recess for 10 minutes. It shouldn't take longer than that. And I'll take a look at this proposed limiting instruction. All right. And then we'll come back. emailed over the lunch break some proposed jury instructions, which I've been able to see on my mobile phone, but because we're having internet issues, hopefully IT can work some magic and let me see on my actual computer. You can move the. I think had sent over something. Then there were two things, I guess, like an initial and then a revised suggestion from the state. Has anybody else sent anything?
And
Oh, wait, no, that's not.
the suggested instructions sent by the state dealt with the.
Right. Mr. Copeland, how to handle Mr. Copeland's thing.
Yes, I have a response with respect to Mr. Harvey's request. but
Okay,
not
if you
a-
want to email that to Ms. Persfield.
It's not a suggested response, suggested instruction. It
Right.
is a response that we should not give an instruction and the reasons why at this point.
Regardless, I haven't seen it. So if you want me to.
I was gonna orally, but I can.
Okay, that's fine. If it's not in writing, that's fine. I thought you were, I maybe misunderstood you. I thought you were saying you had sent something over. But no, if you just want to orally say, here's why I don't like Mr. Harvey's instruction and why we shouldn't give one, that's fine. I think if we do give it, we need to work on it. And I'd also like to maybe sort out from Mr. Harvey. I'm trying to find it. There it is. So there's the kind of limiting concept about RICO versus other counts, but then there's also included in the same instruction, hey, here's how you might consider prior statements. And are you just proposing that I give some general instruction like this at one point and then we move on? Or I'm not sure what you're proposing.
Okay. When, for example, we have Mr. Copeland on the witness stand, we've spent an inordinate amount of time going through his prior statements.
Right.
To weed out those portions that may or may not be admissible. But the point of the prior statements is that he is being impeached.
Right.
From his testimony at trial. And if it is impeachment evidence, then it can be considered with regard to the credibility of Mr. Copeland and for the act in question but not for any other purpose. That is, I guess, my point. And, you know, we just got a potential witness list with exhibit descriptions, which includes the captions impeachment in some of the categories and some of the exhibits. And I know those are potential depending upon what the witness testifies about, but we're clearly in impeachment territory with Mr. Copeland. So I understood Your Honor to say, look, this may be admissible against everybody because they're all charged in count one. And that was the first part of my proposed instruction. That's what I understood you to say yesterday. And I don't really have an argument.
You know what? Thanks for bringing that to my attention, because you're right. I guess, yes, during this exercise,
yes.
I guess at some points I've been thinking about, okay, substantively speaking, how does this come in? And you're right. If we're thinking about certain of these things as coming in only if they are prior inconsistent statements, then yes, you're absolutely right. So yes, thank you.
Well, that's why it was kind
Okay.
of joined together.
Okay. So I guess thank you for that clarification. And then also what I'm asking is, are you suggesting that I just give this general instruction to the jury, you know, basically whenever we restart the trial on Monday? Or are you saying before each kind of thing comes in,
well, I don't necessarily know whether you need to do it beforehand. And that was the old rule prior to the new evidence code. And I think the old cases, and they were old cases from like 1990.
Can you try to speak into your mic?
Oh, I'm sorry.
I know it's a lot to do at once.
The old cases were from like 1998, and they said you got to give it beforehand. And you said that yesterday. Boy, I think you got to give it beforehand. And I don't think that's the rule anymore. And I think if you look at the new proposed jury instructions for the Superior Court jury instructions,
Yeah.
it says, and I'll quote, note, new code section requires the judge to give limiting instructions when applicable on request. Probably better to give, if applicable, whether requested or not. Now, if witnesses are not impeached by prior inconsistent statements, then it's unnecessary to give it. If they're impeached after and there's a prior inconsistent statement that may be admissible, I think after that evidence comes in, not before, because you won't know necessarily.
Sure.
You can say, you know, this is admitted as impeachment, and it goes to the credibility of this particular witness. That's my request.
Okay.
That's why it's in two phases.
Well, yeah.
Or two paragraphs.
Yeah. As you proposed it, that's kind of what I'm trying to sort out is they are two different topics. Do you want it as just one big instruction, or, and no, I don't think that it's appropriate every time a witness is impeached to say, hey, this might be impeachment, or this is or was impeachment, and here's how you consider it.
Well, it may
and not talking necessarily to kind of impeachment evidence, but sometimes there's other evidence that comes in for a limited purpose.
I agree. And I have asked for instructions when I thought, and the state has objected, and they've said, look, it comes in against everybody, and I understand their argument, and I could probably give the opposite, the same argument that I know Ms. Love is going to stand up and give.
Yeah.
But I have asked for those instructions, And when evidence comes in as impeachment, I'm going to ask for the instruction and have it limited to that particular count and that particular person.
Your Honor, I would.
Yeah.
Just as to Mr. Harvey's words regarding evidence that comes in as impeachment, I'm hearing, and I'm aware that he may not be saying it as I interpret it, but this makes the second time. Once he previously, before Your Honor began presiding over this case, once he expressly said impeachment evidence cannot be used as or is not substantive evidence. And I wanted to just make clear that under our evidence rules, impeachment evidence is in fact in the form of a prior inconsistent statement. A prior inconsistent statement is substantive evidence, not just impeachment evidence. So to the extent that Mr. Harvey is asking for any kind of limiting instruction because we ask or we admit a prior inconsistent statement that is impeachment evidence, I would object to that, because that statement now becomes substantive evidence that is admissible, not just for one person or to, somehow attack the credibility of the witness on the stand, but now it becomes substantive evidence of what is stated, of what is given in that prior inconsistent statement. And because each of the counts in this indictment are alleged as overt acts in count one, and everyone is charged in count one, a limiting instruction based on Mr. Harvey's interpretation or assertions regarding inconsistent statements and the acts alleged regarding, or who is alleged to have physically committed the acts, would not be proper. The response that I have to the overall requested instruction he has, it makes it, it goes into it a little bit more, why it would not be proper, but just based on what he has just said, we would object to that primarily because an inconsistent statement is substantive evidence.
All right. Well, with regard to the beginning of your paragraph 1 that doesn't concern prior statements, that I think is meant to concern the RICO count, that needs to be much more specific. So maybe if you could endeavor to make it more specific as to, if I'm going to give the jury an instruction, I want them to actually benefit from it. So, let's talk specifically as to RICO, and then I guess I am asking, prior statements aside, as to the RICO issue and then the substantive counts issue, is your proposal that I say this once, hey, these people are charged all in count 1, which is RICO. Certain people are charged in other counts, other people are charged in different ones, and we can be specific about it. But as you hear all of this evidence, keep in mind that it can all be considered against everybody with regard to your determination of whether the state's made its case on count 1. But it can only be considered as against the defendants who are charged, as do everything else.
All right.
And give that once, or give that, I think give that once, because otherwise it's, okay, now I don't know if we're going to very cleanly break each time from, all right, this is counts 2, 3, and 4. Now we're done with that. This is counts 5, 6, and 7, you know, so that I could separately charge each time.
But the jury has to make the determinations as to the predicate counts. Did the state prove that first place?
I know.
This predicate count. Did they prove this predicate count and that anybody else may be a participant or should be? That conduct should be imputed to anybody else. That's the issue.
That's the whole concept of a conspiracy, Enrico.
I get it. But when you are admitting inconsistent statements.
All right, now, I don't want to talk about inconsistent statements right now. I'm talking about how to handle the RICO count and what should be limited with regard to that. Okay, we'll get to the inconsistent statements in a minute.
We will try to make it more specific and resubmit it. If that's what I understand.
All right. Yes, and then do you all think that and I know you don't want one at all from the state on how they should consider other charged crimes against everybody as for RICO, but not against everybody as for guilt to that crime itself. But assuming I'm going to give one anyway, is the best way to do it a one-time, let me explain this to you and how you consider it, and not every time we move to a potential different crime. I'm leaning that way. So I'd like for y'all to try to craft something that way. So anything else on that?
Just to say that broadly, to give an instruction at any juncture other than the end as it relates to the RICO count and how it should be considered would be confusing and premature because it would be incomplete. Especially the way that we've seen it in Mr. Harvey's proposed instruction. So just as much as the court is asking, how are we proposing instructions be given on, during or throughout or at one time at the end? Our position is that regarding this topic, at the end, at the very least, one time at the end, and we have more to say that we can put in writing in response to Mr. Harvey's.
Okay, well, I don't think it's particularly helpful to have the jury not have any idea how they are supposed to be considering and evaluating this evidence while they're listening to it. And I know they're not deliberating on the evidence until they all get together at the end of the case. And I know that they are not making any kind of determinations about it until they're deliberating together at the end of this case. But as they're taking it in, it might be helpful to have them know how to be conceptualizing it. And if this were my trial from the outset, yeah, it would be pretty bizarre for me halfway in to be like, oh, hey, by the way, here's an instruction about it. I would have done it before now. But if I'm going to do it, it's not that weird for the first time they see me while I'm telling them other things anyway to say, and hey, this might be helpful as well. Here's something that you need to think about, and here's a way to think about it. So what I mean for that is, and I mean, I think I'm making the decision anyway. I think the appropriate way to do that is to give that instruction once and then give it again at the end to remind them, but not throughout the entirety of the trial each time we move from one set of crimes to another.
So Your Honor, I'm going to let Mr. Atkins address part of what the state's response is. And then if the court will permit me, I just have to say a little bit more after he addresses the first part. Go ahead.
Your Honor, I just wanted to highlight that I think an important thing to consider, because there seems to be conflating the concept of relevant evidence and admissibility at trial. with every defendant being charged in count 1, the RICO, evidence of, for example, Act 39 we talked about, Mr. Winfrey. If the jury finds that overt act was made by Mr. Winfrey, that is relevant evidence to their overall determination. And so I think any instruction, if the court were to give one, I think, as the court alluded to, it needs to illuminate something in the jurors' minds, not confuse them, but explain something. With every defendant having count 1, there's no defendant who's not charged with that. So all of the overt acts which track the indicted counts, if someone is not mentioned in evidence presented in Act 39 and defendant X is never mentioned, the jury never hears any evidence of that specific defendant, that evidence is still relevant when they're deciding count 1 for that defendant who was never mentioned in said act. And so and of course, RICO trials of this nature, the jury instructions, they take a lot of heavy lifting legally and thought. And the case law makes that clear, that what instructions the jury are given, it's very important to be clear and concise, because it's naturally, with so much evidence, it's important to get those instructions right. And so I think that is just an important thing to keep in mind, of relevancy versus admissibility. And some of things in regards to relevancy, if they're admitted by this honorable court, any argument can be made at closing of why it is not tethered to their client, or why the state didn't prove count 1. And I just wanted to share that because I think it's important when thinking through this, and to ensure as well, given the endeavor of jury instructions at the end of trial, that whatever we instruct the jury now, we don't want to instruct them something different later, after a more fleshing out of all of the jury instructions. Because of course, jury instruction as a whole are what's considered from appellate courts in terms of if one specific instruction was proper or improper. And so I just wanted to highlight that for the court while we're thinking through this.
Okay.
And Your Honor, I just wanted to tag on to that, that I heard Mr. Harvey reference predicate acts, and I wanted to just emphasize how overt acts are not necessarily predicate acts, and we don't have to have any predicate acts in this case. And Mr. Harvey's instruction that he's given the court so far is just wrong, in that it implies that evidence introduced under count 1 is not something that can be introduced against every defendant. Just to follow up on the admissibility or relevance distinction Mr. Atkins just made. The other point that I wanted to make is that understanding the court's inquiry and concern about instructing the jury and making it clear for them how they are to consider evidence as we go along. My question regarding the instruction that Mr. Harvey has proposed is, what problem exists right now that we are trying to solve with the instruction? And my answer to my own question is that there is not one at this time prior to the close of the evidence that requires us to give the type of limiting instruction that Mr. Harvey is requesting. Right now, as it reads, his instruction it's misleading and it's confusing.
Well, yeah, it is not particularly helpful at this point in time. It's a start, because he at least said something. So, which is what I've been asking everybody to do for the last week and a half. But yeah, no, it's not what we're going to use. It is not particularly elucidating, but it is at least something. So thank you for that, at least.
May I respond? I'm sorry. I didn't know whether you're done or not.
I was just going to point out that his instruction, it sort of implies something, but that proof of a substantive RICO violation is not an element of the conspiracy violation that we've alleged in our indictment.
Well, and I mean, in all honesty, nothing about this even mentions RICO, which is what we're trying to clear up for them. So it needs to be much more specific and targeted also. I mean, this is just general amorphous,
Well,
not helpful.
that, you know,
Sorry.
I understand, and it's very hard to pinpoint. I think it's extremely difficult. And in that sense, please don't quote me. I agree with the state. First time in my life, perhaps.
Yeah, probably so.
But I think what the state is doing is conflating the gang charges, because if these go to the gang charges as well, then I want you to instruct the jury every time gang evidence comes in that the mere participation in illegal activity with a gang member or gang members does not, as a matter of law, constitute gang activity.
Right. It's got to be in furtherance of the gang. And I will give an instruction to that. It will not be every time gang evidence comes in. That'll be an end of the case
But
instruction.
that's what's being conflated here. We're getting RICO evidence, we're getting gang evidence, and it's coming from the same witness. And that makes it very difficult to parse out, given that kind of.
That's why we're going to have really good instructions.
And Your Honor,
I agree.
The gang is the enterprise that is charged.
I understand. So let's get something much more specific than this. Now, on the prior statements thing, sometimes they're only impeachment and sometimes they're substantive evidence. So it's not true that every time a prior inconsistent statement comes in, its only way that it can be considered is as to the credibility of that witness. It's not true.
I concede a split in authority. The 11th Circuit specifically says that impeachment evidence, inconsistent statements are.
Are they talking about Georgia evidence or are they talking about their own? So then it doesn't matter what federal courts say about it.
But it's the same rule. It's the same rule. And I get it. I conceded that. I'm conceding. I'm arguing. It's the same rule. It is the exact same rule. The Georgia courts have specifically said we're adopting the 11th Circuit. So I think there's some disagreement, but I concede the Georgia rule. But sometimes it's still just impeachment.
Sometimes.
So, and the state has said several times, both in their exhibit description and today when arguing to Your Honor, that's impeachment evidence. If we may just want to impeach them with that. And that would go to the credibility as to that act. And Mr. Nichols is not charged in that act. So I think, and again, I agree, it's very complex and it's hard to parse it out. And I think it's difficult for us in the court. I know it's difficult for the jurors.
All right. So with regard to prior statements, it's kind of whether we're talking about a witness who's testifying or it coming in some other way. But when you're impeaching a witness who's testifying with prior inconsistent statements, it's substantive evidence when it comes in. So, all right. Now there's the other issue of the jury instruction I am going to give. And obviously one jury instruction I'm going to give, we had discussed before, and it's, and I had read it out, but upon further consideration of some of the motions that have been filed since that time, including the kind of new spin on Mr. Stillwell's motion for a constitutional and fair trial with requested relief. And just considering some of the motions that have been filed, I think by Mr. Williams since, I am actually reconsidering and have reconsidered and made a different decision about, at one point I had said I was going to just say disregard any comment about any of the actions of the lawyers. And I'm going back to the proposed instruction with that. And I'm going to say that may have been disparaging of any of the lawyers in this case, because I mean, it is a fact that on the record, some things were said about certain defense counsel that anybody who's an attorney would consider disparaging, unprepared and unprofessional. So I'm going to address that and seek to cure that by just using that actual word. So that has changed with regard to my just general opening instructions about being the new judge on the case. Now we have to decide how we're going to instruct the jury about what to consider and what not to consider as to Mr. Copeland's testimony. Now, this assumes, this assumes that Mr. Copeland decides to testify. Obviously, if he decides at this point, you know, on Monday not to take the stand at all, then it's a pretty easy instruction because it's disregard everything you heard from this witness. But if that's not the case, then does anybody have a proposal for how we are going to, and I think that's what the state had sent something on. And has the defense had a chance to look, and is there, I think Mr. Williams maybe has just sent over his proposed instruction, which hopefully everybody has gotten. All right. All right. So Mr. Williams' motion, his language, that looks pretty good to me. Obviously, we don't need to include the case law sites, but I mean, that looks like a good thing to sort of work from. Now, one thing I guess I was asking, but not very clearly yesterday, was it seemed like there was kind of a fairly clean break between the topics that were covered before the recusal motion and the topic that was covered after the recusal motion. And that being, I think like on the one day, the question opened with, all right, now let's turn to the murder of Nutt or the murder of Donovan Thomas or whatever. And that was after the recusal motion had been filed. So was there any discussion of the murder of Donovan Thomas with Mr. Copeland prior to the recusal motion? Because it would be pretty easy to also say, not just with regard to dates and times, but anything about the Thomas murder, disregard, if that only came up after the recusal motion was filed.
Your Honor, with respect to any reference, I haven't had a chance to listen to all of it and read all of the testimony that and all of the questions that Ms. Hilton asked of Mr. Copeland. But I can say that so I at this time, I would ask that the court not instruct the jury as to disregard any specific subject, because.
Well, I'm wondering, so I mean, y'all have had the the point of getting y'all all the testimony was, well, one of the points was so that you could look at it.
Yeah.
Uh,
I mean, I'm not saying I haven't looked at it. I'm looking for and reading.
Yeah, so I mean, if there is kind of a break in terms of subject matter as well, that'd be an easy thing to instruct on. But does anybody know the answer to that?
So
You do? Okay. What's the answer?
I misspoke yesterday, but there were video portions of Mr. Copeland's statements on early morning hours of January 11th, 2015, as well as January, I think it's 21, 2015, played for the jurors. They were small. They were like, quote unquote, real impeachment.
Right.
After that, though, after the motion to recuse was filed, is the wholesale playing of various recordings. So I don't think that it would be appropriate to say disregard everything. I have all my notes and I have the transcript.
Okay.
But he did discuss things that you're talking about. He did discuss his relationship with Mr. Williams, his relationship with Donovan Thomas, with Mr. Kelvin Watts.
Right.
So he was getting there.
Okay, but if it's all that sort of background relationship stuff, that's not the murder of Donovan Thomas. That's all the background. So what I'm trying to sort out is, had there been any testimony about the actual, here's the night of the murder stuff before the recusal motion?
So, Judge, it's when you say about it, in as much as it's relevant to the issue of the murder itself, that's the reason why I was asking the relationship between parties and all of those kind of issues.
That's not what I mean. And we can be clear about that. I mean, the night of the murder, the what happened, how the murder went down.
I think it's safe to say that as far as Mr. Copeland is concerned, the specifics of the night of the murder information or evidence was given post-recusal motion.
All right. Is there anybody that disagrees with that? All right. Thank you.
Specifics of the night. And Your Honor, would the court consider the state's position that in characterizing any evidence in any way, it could imply to the jury that certain other evidence does not fall into that category? So in other words, any evidence of the night of the murder, I'm not certain how the court will be instructed.
I'm not either. That's what we're supposed to be tailoring today. That's what I wanted y'all to be giving lots of thought to. But yeah, no, I want to tailor it in such a way that I don't mislead the jury about anything. But y'all all agree that we have to tell them to disregard some of it. And I mean, yeah, maybe the cleanest thing to do is, XYZ date, but people don't normally think about their lives in, June 3rd. Okay. I know exactly what June 3rd had to do with, unless it happens to be their birthday or something like that. But so, yeah, I mean, I'll consider all of what you want to offer me, but okay.
Personally, and I'm not speaking for, I went by my notes as well as a transcript.
But my notes have more things, I guess. I don't do my notes. But I don't have anything specifically talking about the Donovan Thomas murder before Mr. Weinstein filed the motion to recuse. I do have like a January 11, 2015 interview by Detective Thorpe of Mr. Copeland.
Yeah.
It is admitted over objection, and it was played from 3:29:46 to 3:30:13. And I have to go back and remember what that was about, but I have little things like that, but I don't have any specific.
That's very helpful. And I knew there were a couple of small snippets of videos played. So if you've actually got the timestamp as to what parts were played, then it's easy enough to have somebody look at those snippets and see what it covered.
Can I announce now or?
Yeah.
So everyone can check. I have State's Exhibit 378Y, as in Yankee, B as in Barry, 6, and these are the time slots, 6:46:34 to 6:46:44, and that's a January 28th, 2015 interview.
Okay.
And then I have the January 11, 2015 interview marked at State's Exhibit 358A as in Elisa, and it's at the time I just said, which is 3:29:46 to 3:30:13. That's what I have. And then I have nothing else about specifically his interviews after the killing.
Okay, 3:29:46 to
3:30:13.
Okay, thank you.
And that's at 358A as in Elisa.
All right, and I think that's our review had only revealed those two, anything from those two videos also. All right, anybody else have a different recollection about either more videos or the specific topic of the night of the murder having come up prior to the recusal motion? If so, please let me know. All right. Silence. All right, turning back to Mr. Steele's proposed instruction. You're saying that as to collecting their notes, they're going to be sealed for the record. Why not just destroyed? And I don't even know if your mic's working right now. We might need some more batteries, but.
I was given more batteries, but this should be working, I hope, anyway. I just, from doing death penalty cases, that we don't destroy anything, but we don't get to look at it the court can look at the notes, I guess, but it goes under seal. That's how I've always been taught.
I mean, why would there be any relevance whatsoever, even on appeal, to what jurors might have written down about something we then take from them and tell them to disregard?
I understand. This is just how
Okay. I mean, if it were a death penalty case, I would do it that way, but.
I'd have to look at the law though, but.
Okay, well.
But I can't answer your question other than, yes, I understand at the end of the case.
All right.
No one gets their
Frankly,
notes.
I don't need to tell them what I'm doing with them anyway. So if I do seal them for the record, I'm not going to tell them that. If I'm going to destroy them, I might tell them that. But so if you want to give me law on that, great. All right. Now, one other thing that I propose to do, because we're telling them there's this chunk of testimony from a couple of days that y'all need to ignore entirely, disregard entirely, don't give it any consideration. What I propose to do, in addition to instructing them on that, is to then do some version of, and Ms. Pursfield found a case that was pretty recent where a court had done this when they were having to say, ignore all that evidence, disregard it. They actually kind of said, and if there is anybody who thinks they can't, let me know. And I would propose to do that whenever I give this instruction, so that if there are jurors who are like, no, man, I just cannot do that. Once I hear it, I can't unhear it. Then we can know that. We could excuse those jurors. And I mean, I guess if it's 8 jurors that say that, then we might have a mistrial, but better to go ahead and figure out from the outset, as far as I'm concerned, can you do that? Instead of just being left with, oh, they're presumed to do it. Okay, so thoughts on that? But it is an appellate court case. Ms. Pursfield, do you have the site for it? It looked like a pretty good idea to me.
Judgment is Davis, Davis v. State, and that is at 307 Georgia, 746. Don't have a pinpoint, but I believe it's towards the.
Yeah, it's towards the end. It's either the last or the second to last topic that the appellate court addresses. And it even includes the instruction, and I may look at that and maybe borrow some from that as well. So y'all can take a look at it too. All right. And do y'all all agree that if Mr. Copeland decides on Monday he is not going to testify, that everything he's said so far gets disregarded?
No, Your Honor.
No, you do not?
No, Your Honor.
Okay. All right. I'd love to hear it, but I'm not sure how that's going to work unless everybody agrees to it, because nobody's going to get to cross-examine him. So if y'all all are like, yeah, every one of us wants everything he said recusal motion, super, stipulate to it, I don't have a problem with it. But otherwise, tell me how that's going to work. Actually, does everybody want every bit of what he said pre-recusal motion?
Yes.
No. Okay. Then how do I let them consider anything that everybody doesn't agree to pre-recusal motion when nobody's going to get a chance to test him further?
So, Judge, there's the issue of what Mr. Copeland wants to do, what he decides to do.
I know.
He may later on, change his mind.
Sure.
And so I would just ask the court to allow us to think about what the court did.
Okay, y'all, I have been asking you for the last week and a half to think about it and to get together on it.
Specifically, if he chooses not to testify, because we were earlier, the court had said that regarding his decision not to testify, there were limitations as to what remedies existed.
Yeah.
And the court said that if we found case law to present it to the court. So
Okay.
I have been looking at that issue, and before I present the court a specific case, I want to make sure it's on point. But I'd like the ability to present that.
Here's the thing. It's Thursday. We are not having court Friday or Saturday or Sunday. I'm bringing the jury back Monday. So
Understanding that, all that I'm saying is that even if the court brings the jury back Monday, and on Monday, Mr. Copeland chooses not to testify, Monday would be premature to tell the jury to disregard what he said, because he may change his mind on Tuesday, and then he comes in on Tuesday and they have to now consider what the court has told them to do.
undisregard it.
Right.
Yeah. Well,
So I would ask that,
well, let me ask you this. Assuming that we have him in before we have the jury in and he says, I'm good to go, put me on the stand, which he will not say in that way, but we still at that point need to say, as to the 13th, 14th, whatever, disregard that, right? I mean, that's the time to say that, right? Yeah. Okay. So I hear you. It may be that he says one thing on Monday, which is throw me in jail. And then by Friday, he's like, I don't like jail. I want to come testify. Then, yes, they get to consider what he said on the 7th through the 12th or 10th or whenever it was, 12th, I guess. But I don't think we leave them hanging in the meantime.
in the same way that sometimes we have to break from a witness if the witness gets sick.
Yeah.
They get sick in the middle of state's direct. It would be not yet right to say disregard.
Okay. What does anybody on the defense side of the aisle think about that?
Oh, two things, Your Honor. First, I think Your Honor indicated that you want to make sure the jurors are able to follow the instructions. And so I don't know how we're going to be able to, without telling them to disregard, make sure that they're able to disregard the instructions. Secondly, if there's evidence that they're not supposed to be considering, I don't want them to be evaluating other people's testimonies further on in this trial while still considering something they're not supposed to be considering.
I think so too. I mean, it's not ideal, but it may not come to pass, but I think that at the point in time when it appears to us, if it appears to us that he's not going to testify, we need at that point in time to say, discard everything you heard from this witness. And then if he later says, you know what, get me out of here, I want to testify anyway, then is when we say, okay, I know I told you to disregard it before, but he's available again to testify. So here's what you can consider. The rest of it, we're picking up from wherever. I just think that's the best we can do. So.
I'm still looking at that issue. Just
Okay, well, I mean, that's fine. If you come up with something, let me know. All right. Okay, so have y'all yet gotten together on if he does not testify, what parts everybody agrees they want? Because there were clearly some parts that everybody wanted. Yeah. Or are you just, because y'all were all like, oh yeah, there's some good stuff in there. So if y'all all agree to it, fine. If you don't, also fine. Probably none. Sure.
After consulting with all parties on the defense side, our position is that if Mr. Copeland elects not to testify, we're going to ask that all of his testimony be struck.
That's
Not
fine.
had the opportunity to cross-examine, obviously,
Sure.
and so that would be our
Okay.
position.
All right, thank you.
Yes, ma'am.
Okay. Okay, I think Mr. Steele, you were going to get me some case law on, what was it on? Something.
I assume it's the statute of limitations.
Yes.
I have a whole brief on this, Your Honor, but
Okay.
in the meantime, if the court wouldn't mind looking at State versus Conzo, it's C as in Colette, O, N as in nice, Z, O. It's 293, Georgia Appeal 72. It's a 2008 case. And they talk about,
Okay.
it's in,
All right, I'll take a look at that.
There's also a federal case that's on point, and I have to find it. I know it happened. It was a lawyer charged with money laundering. It's in the trial was a district court in Maryland, so it would be, and my mind's gone. What circuit would that be? I can't think of the
If it's in your brief and you can point me to
I
your
can.
brief, that works.
Did we just get that brief?
I'll send it to everybody.
Is this something new that has not yet been filed?
No.
Okay, yeah.
And I don't know if I filed it, but I argued it. So I have all the relevant cases.
Okay, great.
And Your Honor, with respect to just the argument that Mr. Steele makes, as it relates to, as I understood his argument is that broken down, that the jury should look at the dates of the acts that are alleged, and if they only find that the state has, one, proven beyond a reasonable doubt acts that have been alleged further than 5 years before the indictment, that the state has failed to meet its burden. The problem with that is that in a RICO conspiracy, overt acts do not have to be a crime, and they do not have to be racketeering activity. So proving the act beyond a reasonable doubt is not a thing, for lack
Not
of
the
a
right
better
standard.
Right.
Not a thing. Okay, I'll take a look at the case law.
And second, Your Honor, that's breaking apart the whole of the RICO, and that's not the way that that's not the law.
Okay.
In fact, and I'll get the case, there's a specific case, I'll get it for the court.
All right.
It is the last date, the last overt act. So we have to prove that at least one, the existence of the enterprise, and at least one person committed one overt act. If that overt act, that last overt act
is within the RICO statute of limitations.
Yes,
Yes.
that is what we're looking, not,
Which may be what the nuance of the case is that, as you just described it, it would be true that if the only thing the state proved, let's assume that for whatever, I don't know if it was a federal or a state RICO, but let's call it a 5-year statute of limitations. And if if they had only proven overt acts, all of which were before 5 years, then none of the overt acts would have fallen within the statute of limitations, and therefore they would not have proven their RICO charge. And that may be what that case stands for. I don't know. I'll read it. I think I followed you. I may not have summarized your argument well, but I think I understand what you were saying, and that may be what that case is saying. Okay. What I'm going to propose at this point is that we recess for about an hour, at which time I would like for you to all put your heads into these proposed instructions and then come back with, something to work from that is whatever y'all want me to consider as to each of these things. And let's try to finalize what I'm going to say on Monday. Okay. So we'll break till, let's break till 3:30, which is an hour and 10 minutes.
20 seconds.
Yeah.
I just do something to.
Yeah. Sure.
We've raised this a lot of times. It's been overruled.
Okay.
But I just want you to, because it's going to come up, God forbid there's an appeal. I don't want the court to feel like we sandbagged you.
Okay. I don't want to feel like that either.
So I'm giving a copy of the case, if I may approach.
You may. Thank you.
Your Honor, on the copy that I've given, and it's United States versus Vendetti, VANDETTI 623 F second 1144. It is the Sixth Circuit 1980, and the copy I've given this honorable court and the state, it's on pages 3 through 4. And then there's another case that I have copies, I have to find them though. It's State versus Thomas, which is THOMAS. And it's 364 Georgia Appeal 148. It's in Division 2. It's 874 Southeast 2D 195. That's 2022. And that's citing to a case that we've all cited a lot. State versus Jefferson, JEFFERSON, 302 Georgia, 435, 807 Southeast 2D, 387, 2017. The Jefferson case and State versus Thomas deal with a guilty plea of a non-testifying co-indictee in a conspiracy gang case. The United States versus Vendetti case deals with a jury verdict on a co-indictee who did not testify. The reason I bring this up to you is it won't have any effect on Mr. Sledge because he's testifying, but the state has successfully over objection brought in, I'm just remembering Mr. Winfrey, but I'm confident they're going to try to get in Mr. Johnson's client, I can't remember, Eppinger, EPPINGER, et cetera. And I just believe that that's a confrontation clause violation.
All right. And where in, you said pages 3 and 4?
Yes, it's in division on page 3 on the right-hand side.
Okay.
And it starts at the very first full paragraph to determine whether the testimony.
All right.
That's in the Vendetti case.
Thank you.
No, thank you. And it's a lot of it. They summarize, they in the Sixth Circuit summarize on page 4, specifically the first full paragraph on the left-hand side.
Okay. Thanks.
No, thank you. I just wanted to use the time.
All right.
Thank you.
So, Your Honor, we have three instructions. Would the court mind just laying them out so that everyone's clear?
So, I think the most challenging one is going to be any sort of a 105-ish limiting instruction on how they are supposed to consider evidence as to the RICO count versus as to the substantive count of the indictment that might be an overt act alleged in furtherance of the conspiracy, which I assume, like, for instance, a few of these defendants, but not all of them, are charged with the Donovan Thomas murder. I assume the Donovan Thomas murder is an overt act in the RICO count. An instruction that clarifies for the jury that when they're considering all of the evidence on the Donovan Thomas murder, it is okay to consider that against all of the defendants, because they're all charged with RICO, when considering whether the state has established guilt, their guilt on count one, each individual defendant's guilt on count one. It is not, however, something that they need to be thinking about when they're deciding, okay, who's guilty of this murder? Mr. Williams is not charged, for instance. So they shouldn't be thinking, is Mr. Williams guilty of this murder that he's not charged with as a murder conviction? And I'm not necessarily explaining it well. That's why I'm asking y'all to come up with it.
So would the court, so within this, and I know that I think this is what the court is asking is, but within the context of that type of instruction, would it not be necessary to have or to give to the jury the elements, like we would need to go through the elements of the charge to say how, when you say consider, you know, how they are to follow that instruction without being given the elements of each charge? How will they know how to?
So I don't know if maybe the way to, or the place to look at it to begin with is where in the pattern jury instructions, there's a pattern instruction about, you know, sometimes things are considered for limited purposes or against limited, some defendants and not others. But I'd like for us to get more specific than that, because if that's all I say, that is really not helpful, because I haven't said, and so here's what you do consider it for as to this person or that person or this count or that count. So work on that. And then, you know, what I'm saying about how we handle Kenneth Copeland stuff. And I'll go ahead and look at these two snippets now that I've got timestamps and see, and y'all can do that as well if you want to make sure that you agree. But that's what I want y'all to be working on. Okay. All right, so we're in recess till 3:30. We use it, you know, at the end of the trial when we're giving them all the instructions. But I'll take a look at both of them. And I know we are going to need to sort of give each other a chance to look at what's been cross-proposed and then edit, come up with something else, and then actually figure it out, which, you know, maybe can happen in the next hour and a half or 2 hours, maybe can't. But this is finally a good start. So, do you need a little bit more time before you send whatever you're going to propose? Okay.
To do it right.
Like
A few
30
hours.
minutes? Like how long?
What'd you say? To do it general. I think that we definitely can do this. And I think that that it deserves, attention. And as you mentioned earlier, that we need to be specific so that the jury understands what we're trying to, what you're going to convey to them. With that being said, I think that it's going to take longer than an hour.
Okay, so I guess I'd rather have it late and good than not at all. But I am having a really hard time understanding from not necessarily everybody, but not simply one person or one side either, why when I say kind of A, over and over again, and B, with a week or more's notice, I would like for y'all to be working on this and provide it to me. Why lots of this is still not provided in a timely manner. And y'all don't have to give me an answer, but I would like for y'all to stop doing that. Okay? Because we are in the middle of this trial, as y'all all well know. And, one of the complaints made by the defense is, man, the jury's been out so long, they're not even going to have any idea what we said before. And the longer we take on everything, the longer the jury stays out. And I'm having the jury back on Monday at this point. And it should not have been a surprise that we were going to talk about this today. And y'all should have already had whatever you wanted to propose ready and in final form. So let's please try to be more timely with the tasks at hand. Okay. Okay. All right. So I think maybe we'll all be here really early on Monday I'm going to give y'all all orders so you can get in early, and we're going to be here starting at I may need to find out from the deputies how early we can have our defendants here and ready to go.
What time do you leave?
I mean, I was thinking 8 a.m. and I know that means an early day for everybody, but since we can't spend 3:30 to 5 talking about this, what can we do? What's the earliest we can do? Can we do 8 a.m.? All right. We're going to be here at 8 a.m. on Monday. And we're going to, finish, and y'all work together over the weekend, over Friday and the weekend, to the extent you can, to narrow down any disagreements or discrepancies and bring to me only what still needs to be hashed out Monday morning. Okay. Yes, ma'am.
Judge, I just want to make sure, so as our position is that some of the instructions would be better given at a different time than Monday. Is it a certainty that the court is definitely going to give it at that time, or is the court open to hearing any, law or any?
It's not a certainty, but it's a probability. And yeah, if you've got law, I'll consider it, but you don't have to wait till Monday morning to send it to me either, but it is a probability.
Thank you.
Okay. Yes.
Your Honor, do you want objections to the state's proposal or just a re-proposal so you can then evaluate it, a separate proposal like this in writing?
Right now, I don't think necessarily want objections. What I'd like is for y'all to try to work together on something.
Okay.
I mean, if you think there's some entirely incorrect legal concept, but I'd really rather y'all try to get together on it first.
I do object to it, but I think that makes sense because I could do all of the objections.
Okay. All right.
Thank you.
Thank you. Okay, so given that we are not able to sort out jury instructions right now, and I think we have dealt with all of the evidence that we think might be, objectionable that we need to hash out beforehand with regard to sledge now. Is that right?
I believe so.
Okay.
I saw some inquiries over the time that we broke regarding a couple of exhibits maybe that were.
Yeah, and I don't know if those were objections as much as they were just, we need to sort this out,
Right.
so.
So certainly we would not be entering the same piece of evidence under two different numbers.
Yeah.
We just wanted to make sure that we got it.
Yeah, no, I mean, so yeah, just take a look at that and yeah. Okay, so yeah, I don't think that was an objection. That was just kind of an observation. All right, so then who's our next witness that we can get through evidence on? Do our motions in limine on. Oh, and Miss Love, I know that you have now given to defense counsel the detailed list, right? But have you given that to the court? Didn't you give them something?
I shared with them the bucket of physical exhibits for sledge and a list from yesterday. And I'm about to send over another bucket for another witness. So as a pope,
good
to be able to give all of the exhibits themselves.
Mm-hmm.
That's what.
So are you then not just, so I understand, are you re-providing the actual exhibits?
That's what I had.
Okay. I mean, that's fine. Fine with me. What I want to have happen though is, have you now only done that for sledge and you're about to do it for one other?
The actual exhibits?
Yeah.
Yeah, because sledge was the next.
Right. Okay. So what happened to the tranche of the first 30 witnesses?
So that's what I was working on.
Okay. They were due yesterday.
So that's what I'm doing. That's what I've been working on.
She really hadn't said much.
I haven't said much. Yes, I.
She was speechless for a minute.
No, yes, I was.
And now she says that's what I've been working on.
No.
Okay, so, and maybe you're confused about what it is that I want produced. If you have got, if all you're using, for example, with Thomas Burnett is demonstrative pictures of the infinity, and they have all the demonstrative pictures of the infinity, and demonstrative pictures of the infinity serve, XYZ date as, item number 73B, that's fine. I don't expect you, unless it's easier for you, to reproduce those things. I do want you to identify it specifically enough that they can go, oh, here are the 10 pictures she's going to use. And I hope you don't have 10 pictures because that would be excessive with this one infinity representative. So does that help a little bit? But I do want it to actually have happened for 30 witnesses at this point in time, because we can't.
So
the way to operate this trial is not witness by witness at this stage of the game. Okay. So do you need clarification beyond that?
no, no, Your Honor.
Okay.
I have all of the exhibits in folders.
Okay.
So what I was doing was trying to extract the specific ones. So for the 30 witnesses, we have the exhibits in 30 folders.
Okay.
And what I had done was label them and extract relevant ones and send them over.
Okay.
And so I won't do that. I'll just go through the folders and put it in a table, because I was actually going to do that for the ones that are listed. I was actually sending the list yesterday. Mr. Atkins sent it for me just to say, hey, here's what we're sending you. But
okay. Whatever is easiest. And I mean, if it's easier to have them each give you a thumb drive, that's fine too. I mean, logistically speaking, you know, I just want them to know with some degree of specificity, here is the actual evidence they are going to be using with this witness, not social media. But
I understand.
what social media? Okay. But they should have been served at this point in time with everything you intend to use with every witness.
they have.
Okay.
And understanding the court's instruction about making sure about anything that the court told me to give to them by now. So both of those, I understand. And yes.
Okay. And so when can they expect the next 27 or 28 witnesses info about which exhibits?
So I'm just gonna upload.
Okay.
Because it'll be probably quicker to upload them to a Dropbox link than it will be to sit and, or maybe we can have some team members. Some uploading. So.
Okay. And can you share it with the court as well, just so I can have it as well? Okay. So by the end of the day?
As in an hour and change?
I mean, I figure you're going to work past 5.
I have.
So what I kind of mean is by midnight. Okay. All right. And then is everybody okay? So are we ready to work on another witness's chunk of evidence that we think might be subject to motions in limine?
You got if the court will give me a minute just to get my list.
Okay.
Your Honor?
Yes.
May I bring up another potential issue?
Yes.
So it's my understanding and belief that that there may be some outstanding Brady material regarding Antonio Sledge.
Okay.
Brady to include impeachment.
Okay.
My understanding and belief is that the state may have met with Mr. Sledge and he may have said some things that would fall under Brady in a prior meeting.
Okay.
Didn't say anything. I don't know what part of that meeting.
So do you two want to huddle together and maybe Mr. Shark can share with you what he thinks got said and then you can confirm or?
Yes. Would the court give us a moment just to step outside now or do?
Sure, or you can,
I don't know what was said.
okay.
I don't know specifically what was said.
So do you have any reason to believe Brady material or impeachment material was shared then? Or you're just saying they had a meeting and so there may be Brady material that stemmed from it?
My understanding is that there may be Brady material.
That stemmed from it, but you don't know what it was.
If I knew what the Brady material was,
Okay.
then I wouldn't have an issue.
Well, since Mr. Sledge's attorney was present at the meeting, so if Mr. Shart has spoken with him, or I don't know where the idea that there was Brady material, there's no privilege, so Mr. Sledge's attorney is a ready source of everything discussed at the meeting.
All right, maybe Mr. Shart, would you be willing to share privately with somebody on the defense? Do you have the same issue with talking to Miss Love that Mr. Steele does?
I don't.
Okay. Would you have an issue with sharing with her maybe the source of your information? And if you do, that's fine. But
I prefer not to.
Okay. All right. She seems a little in the dark on what might be. I mean, I don't know.
Not the source, just if he would, just the content. I don't know what he's talking about.
I don't think he does either. Apparently he got some tip that Sledge may have provided Brady material, and that's about all you know. Is that right?
If there is anything inconsistent with what Mr. Sledge has signed in here's my concern, and it's I get that this